8টা विटनेस माने 8টা विटनेस बाकी रही 18टा सरी जाइए आ ये 8टा विटनेस को करने आम से रिलेवेंट विटनेस गुड़ाक से इंटेंशनली से करूना से पकई जे माने एक्यूज स्टेटमेंट नहीं गले आर्गुमेंट पकई याडे 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 मु रिकॉल कली.
Do you think that the court is so powerless that I can't put the clock back?
No, my lord, I am not saying my your lordship. Mane am mo koiba
Friday take it.
na my lord podju my lord.
No. I can't take it for evidence recording. What are you talking? I am accommodating you because you yesterday also you mentioned.
Yes, my lord.
And go and tell that I am taking up on Friday.
Yes, my lord.
Take it in Friday.
Tomorrow, my lord.
There.
Mo file koli your lordship.
Move application. I can't accommodate you because heaven is not going to fall. If argument is taken place, you will not be convicted in the same day.
I am obliged, my lord.
Then I am taking it on Friday. You go and tell.
Yes, my lord.
Maximum that I can do. Beyond that, I can't. Yes.
Pardon your lordship.
Every bit, my lord.
My lord, item 73.
Once the matter is taken up, you file
Second,
it.
second.
Don't keep. Where will I keep?
Yes, my
The file is not there. Nothing is there. You are giving the paper.
My lord, item 73. My lord, the appellant has taken out the brief to engage the senior advocate, senior counsel. Yes, my lord, I pray for
Engaging senior counsel file did not be taken. Advocate, senior counsel can't file the wakalatnama.
Yes,
He
yes,
only
lordship.
appear.
Yes, your lordship.
Then you can also brief.
But he taken away the file from us, your lordship.
Then why do you say senior counsel?
My lord,
Say that another counsel.
yes, your lordship. As he stated, my lord, the appellant. Let it,
Then
my
what-
lord, after vacation, your lordship.
No, sir, then I'll have to issue notice to the petitioner.
Appellant, appeal, my lord, criminal appeal.
Criminal appeal.
Yes, sir.
Notice has to be issued.
73.
73, your
Vigilance matter.
vigilance matter.
Vigilance.
73.
3, your
Vivekananda Patna.
ସେ ଇଏ ହବ ଆସୁ ଛୁଟି ପରେ ଆସୁ
Criminal appeal. You are Mr.
A.K. Tarai.
Huh?
Mr. A.K. Tarai, Home Kumar Tarai.
Your name is not there anywhere.
But on behalf of Mr. Puspalaka, my senior, Subhash Chandra Puspalaka.
Mr. Tarai, learned counsel for the counsel appearing on behalf of Subhash Chandra Puspalak. States that the client has his clients has taken the file from him. No more appearing in this matter. Issue notice to the petitioner. Appellant.
Appellant, yes.
June, July. Okay.
Yes, deeply obliged.
Ideally speaking, you should have written a letter to your client that I am no more appearing, and that should have been placed on record.
Yes, Lord. Our name may be deleted, my lord. From the
You
court.
write a letter. I have been discharged and notice has been issued to you.
Yes, Lord.
Next.
ପାର୍ଡନ ମ୍ୟାଡ଼ାମ 78 ମାଇଲର ଏଠି ଏଥିରେ ସେ ଝିଅର କୌଣସି ଡକୁମେଣ୍ଟ ନାହିଁ ତ ସେ 10-15 ଦିନ ଲାଗୁଛି ଆଧାର କାର୍ଡଟା ଆପ୍ଲାଏ ହେଇଗଲାଣି
What do you want?
ପ୍ରିଭିୟସଲି ଇନଷ୍ଟ୍ରକ୍ଟେଡ ସେ ପିଲା ନାଁରେ କିଛି ରଖିବା ପାଇଁ ଆଧାର କାର୍ଡରେ ଆମର 78 କମ୍ପ୍ରୋମାଇଜ ମ୍ୟାଟର ମାଇଲର
Compromise matter, nobody is coming forward.
Your lordship
At the
directly.
end it is July.
ମାଇଲର ନାଇଁ 6-7 ଆଡକୁ ରଖିଦେଲେ
So how many
ହେଇଯିବ
time I will give you opportunity? You
Oh,
say that
please.
it is settled. You don't bring people.
ଅଲରେଡି ଆଧାର କାର୍ଡ ହେଇଗଲାଣି ଆଉ
I don't know what problem you have. How do I know?
ମାଇଲର 6-7ରେ ନାଇଲେ
It can be.
7
Item.
7 oblige ମାଇଲର
Yes.
Lord, I may be pardoned, Lord. I am on virtual mode.
Sorry?
I may be pardoned to make a mention.
Yes, yes.
Lord, BL APL 1267 of 24.
Mm-hmm.
It was specifically adjourned to 19th March. It has not come.
We'll see. Bail matter. Yes.
If it is tied up, then I'll go.
1267 of 24.
Yes. Yes,
I
I
know.
know.
lord. Yes, Belgium matter.
Belgium.
lordship on matter posted to Archer 2024 lordship, but it is delisted subject relating to maintenance amount. So lordship will state the same.
Give the memos. All the memos will give.
Another bell
Yes.
matter.
Yes. No.
Item 1.
Pardon for mention, my lord. My lord, CR C number 653.
What do you want?
My lord, it is for fresh admission. This matter is not listed yet.
First matter, serially it is there.
2844 of 2024. I would actually 2869 of 2024.
Serially these matters are coming up.
No, previously also I filed a memo before this court, but till yet this matter is not listed.
See whether it is jump.
I'll check.
Huh?
I'll check.
Give the memo. Because
Madam.
serially it is coming. If your matter is not coming up, we will inquire.
My lord, much obliged.
Yes. Yes.
Item 1.
Yes.
My pleasure, Lordship. One predicability here, because the order which has been challenged before your Lordship was passed in the year 2016. I do not know what was the development in the trial court, 21, sorry,
Hmm.
21.
Hmm.
The point involved in this case is whether the
What is this order? 2990.
order that is a discharge petition was filed
Hmm.
and that was rejected, and on the same day charge was framed. My grievance is very limited point. So far the other offences are concerned under the Indian Penal Code, I have no grievance nor I am agitating. But the question is whether the case can be proceeded under the SC/ST Prevention of Atrocities Act or not. That is the core question which is to be decided.
Hmm.
Here I examine the entire paper. There is no whisper from the side of the prosecution that the victim belongs to scheduled caste or scheduled tribe. No document was collected showing that she belonged to scheduled caste. That is the whole question involved here.
Hmm.
So that says-
According to you, the accused is from which caste?
General caste, madam.
According to
Accused, there is the admitted fact accused belongs to general caste.
But the report given by the Tahsildar, my lord,
Huh?
Mahanga,
Hmm.
he has given that the victim, my lord, the Kaibarta by caste and belongs to SC community, my lord. The report.
that is there.
କୋଉଥିରେ ଅଛି? Trial court record ଅଛି?
ମଗାଲା
ଆରେ trial court record ତ
Record ରେ
ନାହିଁ।
କଣ ଅଛି?
କୋର୍ଟ କଣ ମଗେଇଥିଲେ କୋର୍ଟ
ସେ ମଗେଇଲେ କଣ ହବ? ସେ କୋର୍ଟରେ କଣ ଅଛି?
ନାଇଁ କୋର୍ଟରେ
The material collected, whether it discloses that
Is
it
that
is-
Tahsildar is one of the witnesses? Charge sheeted witnesses. Are you going to examine him?
In pursuance of this only court, my lord,
Hmm.
18/5/2023, a report called from the Tahsildar whether the victim belongs to SC community or not, my lord. The report has come, my lord, and he has written that the victim belongs to Kaibarta by caste, my lord, belongs to SC.
This court has asked for a report,
Right.
but the request comes from the petitioner.
Coordinate bench, my lord, but the my
କଣ orderଟା ପଢୁନୁ କଣ
ନାଇଁ,
orderଟା ହେଇଛି?
Where is that order?
17 May 2023, another council, my lord, appealing for the state, he called for the report, my lord.
No,
But
there
the-
was no direction from this court.
18/5/23,
18/5/2023,
my lord. Not in the AGA.
place for adjournment.
Instruction, AGA, take instruction, the victim belongs to scheduled caste or scheduled tribe.
There is no.
My order, records was.
ସେଇଟା ହେଲେ ବି ହେଇପାରିବନି।
ନାଇଁ ଆପଣ just check it up whether any material is
Is
there,
there any whisper
in the-
that she belongs to?
or if you arrayed any witness
My lord.
Stating
like-
that she belongs to scheduled caste.
yes, witness, how will you prove it on
My lord.
record that he
My
is
lord.
an AC? Check it up and tell me.
My lord.
ସେ କୋର୍ଟ ବି କିଛି ଲେଖିଲେନି ତା ଉପରେ।
ମାନେ କେବଳ ଏଇଟା ମଗା ହେଇଥିଲା ଏଟା ପଳେଇ ଆସିଛି ଆଉ ଡେଟ୍ ଅଛି।
May first week. You check from the record.
ଆଜ୍ଞା।
This may be correct,
My lord.
but unless this document goes to
Madam.
the record, then how will you prove it?
Whether the IO collected during investigation that certificate or not, I did the question. Right.
Okay, may.
Item 2.
Lordship, permitted to be withdrawn.
You have filed a memo?
My lord,
File a memo. Withdraw,
Madam.
on request, Glenn Mahapatra, Lakshmindra Mahapatra, and counsel for seeks to withdraw petition. Yes, yes.
Item 3. Item 3.
How many matters are there today?
Arjan, my lord. 105.
Hmm?
105. Revisions ago. Revision appeals.
I think they are there.
Appeal 9 appeals.
See, interim order is there. Release the matter. Release the matter. It is being urgent time to time. Time to time. 1, 2, 3, 4, 5.
Two. Three, but? Three.
On the you are on 3.
3, my lord.
Yes. How many times you have seek time?
16, my lord.
You will not decide. 1, 2, 3, 4,
The-
5 times you have taken
Notice-
adjournment.
yes,
Now you
madam.
are fixing date yourself.
The
You
opposite
fix
party,
a date on Sunday and argue yourself.
no,
What to
the
do?
opposite two is not coming.
But I am
my lord.
asking 1, 2, 3, 4, 5 days
Yes,
you have
yes,
taken.
my lord, yes.
Why? What is this matter?
Mr.
Where
President,
is it?
13B was allowed.
Huh?
13B was allowed by the parties, my lord.
Huh.
498A. Another offence are there, my lord. The opposite party note 2 is the husband.
Right.
He has not come, my lord. The issue notice to the opposite party note 2, my lord.
Is it settled? The matter is
Yes,
settled.
matter is settled and 13B was allowed. He has received the warrant alimony.
You are the wife.
I am the petitioner husband.
Wife opposite two.
Opposite two.
Opposite
by-
party. Okay, notice has not yet been
No,
issued.
no, no. my lord.
And earlier occasion, my friend said that he
Yes.
bring the.
That's
Both-
that's
both-
the
both.
reason.
He has not come, my lord.
How you notice?
Notice it to the opposite party note.
Well, simply issue notice to opposite party note.
Two.
That you could have done. You have wasted 5,
Yes,
6
ma'am.
days. Anyway, issue
Okay.
notice. Learned counsel for the petitioner submits, Mr. Samantraj, learned counsel for the petitioner submits that the parties have indeed settled their dispute and moved an application under section 113
B.
B of HMA Act, and the family court
Jagatsinghpur.
Jagatsinghpur has allowed the application and dissolved the marriage between the opposite party number 2 and petitioner number 1.
One.
Petitioner number
One.
1. Petitioner number 1. Issue notice, and this the present petition is filed by the petitioner seeking quashing of the FIR laws against them by the opposite party number 2. Issue notice to so and so opposite party number written about so and so. The in the internet name the proceeding before so and so court is stayed.
Yes.
You could have done it. You wasted 5, 6 days.
She taken 5 lakhs rupees. Not come.
That will not come. That's the reality.
But
Yes.
item 4,
I have stayed the proceeding. File the requisites and I yes.
May I please, your lordship. Lord, here I'm challenging the order passed by the additional sessions at Gunpur, not challenging actually. Here what happened, your lordship, the vehicle of the petitioner was seized by the police. It was there in custody, but on a bare perusal of Annexure 6, it is clear that the court's order, it is clear that no charge sheet against the vehicle is there. The petitioners are not implicated in the case. There is a NDPS case where the petitioners are, the petitioner is not involved. He is not named in the charge sheet also.
Petitioner is not involved, but petitioner's vehicle is involved.
No, neither of them, my lord. Neither the petitioner nor his vehicle.
Then
But his-
you moved application under
yes, because that police charged, police seized the vehicle and kept in the police custody. Thereafter, to release the after 2 years, I filed the application under section 457 of CRPC, and the learned judge also taken note of the fact that your lordship kindly looks at page 61, my lord.
Where is the order?
Yes, it starts from page 55, annexure 6. The relevant portion is at page 61 from the top, my lord.
Which annexure?
Annexure 6, your lordship.
Okay.
It starts from page 55 and the
Yes.
operative portion is at page
60.
61.
61.
Just before that, page 60, para 5. I'm reading it for
Yes,
my lord. Therefore, considering the ratio decided by the Honorable Court in the cases cited supra, and in view of the discussion made as above, since the alleged car, it is an Alto car, my lord. This car has been taken into custody from the possession of the petitioner on 13/11/2021 and subsequently seized on 2/4/2022. Since neither the petitioner nor the registered owner has been arraigned as an accused in TR number so and so, I'm inclined to release the seized
Who
mark.
are you? You are the registered owner.
He is not the registered owner.
My lord,
Who are you?
my brother is the registered owner. There is a section
He has
29.
to move application. Who are you?
My lord, section 20, form 29 was executed. I purchased that vehicle, but due to the seizure,
If your brother is there, he can move application.
my lord, yes, and the vehicle was released, my lord. Vehicle was released by the.
Then what is your grievance?
My lord, I want that any charge, because the terms and conditions which has been mentioned, that I will not sell the car, I will not transfer the ownership, and I shall keep that car with me.
You go and move application there. How can I alter?
My lord, that is not
I
my
don't
case.
know.
Yes, my lord, that is not my case, because the car has been released, but it is
If
not
you
in
are-
movable
if-
condition,
if-
my lord.
If you are, then I shall I go and repair it, not movable condition. Then what can I do?
My lord, the entire charge, why that car is there, why it is really, it will be released on bail, my lord. Any allegation against it, any charge against
What
it.
do you want? I
possible.
don't understand. You have vehicle is released.
My lord.
What do you want now?
My lord, that proceeding against my vehicle, if any pending, that court also don't
You
know.
move
which
application there. I can't alter. I don't know anything.
My lord, 457 he is already allowed, my lord.
Petitions submits that although his application under section 457 CRPC was allowed and the vehicle was released, but the release of the vehicle is subject to various conditions imposed by the court below. He is agreed by the condition imposed by the court below. He seeks to withdraw this petition to file a press application for the Court of Additional Sessions at Gunpur for variation of the condition imposed while releasing his vehicle. The liberty is granted to him. He may move application for variation of the condition. If such application is moved, the same shall be disposed of on its merit. Because there is no provision to alter. It is not like bail condition.
Yes, your lord, the CRL change kariye, yes.
439.
Yes, your lord,
I
keep
can
that
think
in.
for.
Well, I understand.
Therefore,
Oblige,
you
my lord, highly oblige.
Go. Yes.
Item 5.
Dispose of, huh?
Oblige.
Yes. Yes.
May I please, my lord, on
Yes.
behalf of Mr. S.K. Dwivedi, kindly to capture.
Adjourn. Yes.
Item 6.
Oblige, my lord. May I please, lordship. The petitioner is challenging the order of taking cognizance, lordship. So in the meantime, the matter was settled between both of the parties, lordship.
What is the offense?
The offense under section 376 2N
294 534 IPC.
294 506 34 of IPC.
What they have married or what? Settlement means what?
As per the instruction of the lower court council, settled between the both of the parties.
Settlement terms of settlement you tell. It is a 376. Whether they have married.
The assurance of
Assurance to marry.
marriage.
You marry and come. Then it will be cost. Anyway, you bring that. Adjourn. Second week.
May I kindly issue notice to the OP number 2.
Why do you have said the settlement? You bring the lady informant. Of course, it bring second week. Let counsel for the petitioner submits that the matter has already been settled. He seeks adjournment to ensure the presence of the parties before the court and to file joint affidavit. Please the matter.
One small prayer. Kindly delete the name of Mr. Satyajit Mahapatra from the list.
Additional name.
Yes, sir.
Let it be there. How does it make it?
He is appear for the informant in a CRLM application in this case.
Anyway,
Oh, please.
right. Yes.
Item 7.
Here in this case, the petitioner filed this revision challenging the proceeding initiated against the petitioner, my lord. Absolutely, as per the FIR, there is no allegation against the present petitioner. Despite the fact that he was taken into custody and he was remained 15 days time. Till date, no, charge sheet has been filed, no final form has been submitted to 2021. He was the headmaster of the school.
Yes.
And in no way connected.
The only limited grievance is the FIR is of 2021. That is dated November 14th November 2021. What is the state?
I have to take instruction, my lord. Today the past date, my lord.
Take instruction.
Yes, my lord. Yes, my lord.
It should be expedited, that's all.
No, because absolutely there is no allegation against the
Maybe
present
you-
petitioner despite
We
the fact
don't
that
know
he
the
was
charge
taken
sheet, you will be dropped out.
Not saying, but how the petition is implicated?
You will be pleasantly surprised when the charge sheet is filed. Wait.
Definitely, it will be,
They may drop the charges.
no, 3 years, they have taken time to submit the charge sheet or final form, whatever it is.
Mr. Raghunath takes time to sort it. Mr. Raghunath seeks an agreement to obtain instructions regarding the status of the investigation in the present case. Adjourned. Yes.
Item 8.
May I please, madam? Madam, petitioner is the challenge 457 before the Lord Magistrate. Petition is allowed, but huge amount of impose for the petitioner. 27 lakh. My letter.
What is the value of the vehicle?
Mega?
Valuation of the vehicle?
Vehicle.
Where is that order?
My letter order dated. Kindly see the petitioner is allowed 28 27 lakh 66,000.
Yes. Let the vehicle containing container so to be released in Jima petition so subject to filing indemnity bond of 18 lakhs. And one solvent surety of like amount.
Gadiro dam
Also deposit 27 lakhs for the purpose of expenditure towards carrying of the animal. That is there. You can't change it.
ମାନେ ଏଟା ଆମର ଫାଇଲ ମାନେ
That-
4-5
that- that
within
is mandate
15 days
of what to do.
15 days ରେ ଯଦି ଆମର ଏକ୍ସପିଡିଏସଲି ଇଏ ହେଇଥାନ୍ତା
See,
ସୁନ୍ଦର ଭାଇ ଆମର
200 rupees per day maximum
ମାନେ ଏଟା
per cat.
ମାନେ ଏଟା 15 days ରେ
That's
ଯଦି
counted
ସେ
for-
ଇଏ କରିଥାନ୍ତେ ଆମେ 457 ପିଟିସନ ଦେଲୁ 6-7 ମାସ ପରେ ସେମାନେ ଡିଲେ କରିକି
Whatever that
ଇଏ
is the
କଲେ
law, how can you say?
ଆଉ 15 ଦିନ 20 ଦିନ ଭିତରେ ସେଇଟା ଲାଇଭ
How
ଅଛି
many-
ଯାହା
how
ଅଛି
many- how
ଦେଇଦେବୁ
many buffaloes?
59
59. All right.
ତାପରେ ସେ କିଛି ଇନଷ୍ଟ୍ରକ୍ସନ ନାହିଁ ଇନଷ୍ଟ୍ରକ୍ସନ ଆସୁ ନହେଲେ କଣ କରିଛନ୍ତି କେମିତି ଖର୍ଚ୍ଚ କରିଛନ୍ତି କଣ କରିଛନ୍ତି
Either you have to pay or state has to bear the expenses because the buffaloes must be there.
18 ଲକ୍ଷ
In
ହଉଛି
some-
ଟ୍ରକ ରେଟ୍ 27 ଲାକ୍ଷ ହେଲାଣି
Gosala, no.
ମାନେ
Forget about
ଯଦି
this.
ଆମର ଜଲ୍ଦି ସାରି ଦେଇଥାନ୍ତେ ଆମର ପିଟିସନ ହେଇଛି 25/4/2023
It is there in Gosala. Who will take care of for the cattle?
ନାଇଁ ସେଗୁଡା ମୁଁ ମାନୁଛି ଆମେ ପଇସା ଦବାକୁ ରାଜି ଅଛୁ
ଦେବେ ପଇସା ନହେଲେ
ନାଇଁ
ସରକାର ଦେବାକୁ ପଡିବ।
କିନ୍ତୁ 6-7 ମାସ ଯଦି ଡେରି କରିବେ ଆମେ କେମିତି ହାଉ ମଚ୍ ପେ
To the petition to move an application before the court of SDGM Khurda seeking variation of the condition imposed by the court for directing him to deposit a huge amount of 27 lakh 66,400. 400. With this liberty, the petition is disposed of. Let the petitioner may move appropriate applications for variation of the conditions. If such application is moved, same shall be considered on its own. Dispose. Dispose of. I have given a liberty. You won't move application. I can't calculate here. You can ask for variation of that order. Whatever you are saying, because.
ନାଇଁ ସେମାନେ ତ ଲେଟ୍ କଲେ 6-7 ମାସ ସେମାନେ ଡିସ୍ପୋଜ ଅଫ ସୁନ୍ଦର ଭାଇ ଆମଲାରେ 15 ଦିନ ଭିତରେ ଏକ୍ସପିଡିଏସଲି ଡିସ୍ପୋଜ ଅଫ କରିବାକୁ କହିଛନ୍ତି
You have not argued. Go and argue. I have given you liberty. Move application. He may reduce also. Next.
Item 9.
Obliged.
I please, Your Lordship. Lordship, here the petitioners have prayed for quashing of the criminal proceeding. Here the offence alleged under section 341, 323, 506, 294, 427 and 34 IPC. In the meanwhile, charge sheet has been submitted. Lordship, it's a counter case between the parties with regard to encroachment of a public government land, Gochar land. And so far the allegation against the opposite party number 2 is concerned, petitioner 2 is not leaving a passage to the petitioners.
It's a government land.
Government land.
Both of you are.
They are fighting. Both are fighting with each other. And case the urgency here, Lordship, the petition number 2, mother and.
What right you have on the land?
I have no right at all.
And he has.
But I have own land just adjacent to the government land. But she is encroaching the OP number 2. Lordship, here my predicament is the petition number 1 and 2 are the mother and daughter. Daughter is a young girl and is pursuing her studies and for searching for a job. That is why, my lord, I approach in the present scenario, I approach this Hon'Ble court. And so your lordship knows for once a criminal proceeding is pending against a person, police verification and other.
What is the allegation against the petitioner number 2?
The allegation against the girl is, let's may see. मैं read in ओडिया तो हमें लिखित अभियोग करने श्रीमती बासंती बारिक so and so बड़ा
नहीं, the petitioner number 2 is the Monalisa Sahu.
हाँ मोनालिसा साहब श्रीमती इंदुमती साहब हम दसो एक झियो स्पेसिफिकली मो ना कोट नहीं लाइन रे 1 2 3 4 5 7 8 15 line from the top. Here it starts from it starts like this. हठात मो घर पाखर पड़ोसी श्रीमती इंदुमती साहू दी पिटिशन नंबर 1 स्वामी अनदास साहू ओ तार एक झियो दुहे आसी मते कोनोसी कारण न थाई सेठारे अर्थात मोर घर पाखर थिबा डालिया गछ को पड़ी इंदुमती मते मोर हाथ मिसा पिठी को दुई पहाड़ पिटिले सेति की बेले तार झियो धरिथिबा मोबाइल ले को फोटो उठाइबे मोर उठाइबा परे तार मां पाखको डाळ गछ बाड़ी छड़ाई नै मो पिठी ओ गोड़ को जोरे पिटिले स्पेसिफिकली मो ना नहीं दी झियो हमर माने से आकर दी झियो मोनालिसा साउथ मो पिठियो गोड़ को जोर पिटले एथिरे मो प्रतिवाद करिबारु मा झियो मते धमक
allegation that my lord while the daughter of the informant coming from his her college on the way the present petitioner
Come to the charge sheet. What is the order?
my lord
Come to the charge sheet.
the charge sheet is submitted my lord 3/11/2016 my lord.
Where is the charge sheet?
The charge sheet
Charge sheet
your lord kindly
see the cognizance. Then comes for the petitioner trying to find the copy of the charge sheet within a week. Please the matter. Yes.
my lord I have filed my lord I have no
You have not filed the full petition and you are worried the question of I file the charge sheet. How will I see whether the cognizance is correct or not if you don't file the charge sheet? What is the allegation against you in the charge sheet and all that has to be seen. You file it within 1 week. Yes, next.
Item 11.
Yes.
my lord till then no courtship action my lord.
Oh, are you talking 307? While making a prayer, do you realize what are you asking for? It is a 307 case, cognizance has been taken, you don't file the charge sheet, and you want that the cognizance order has to be quashed, and thereafter you are asking for no court action. File it, at least you should completely file the papers you have to file, allow the court to see what are the allegations. It is the case of 307.
my lord
And you have filed 482, you are asking no court action. You have to go to some other court for that.
my lord kindly take up next week
Yes, I am giving the time. I am giving next week. I want to file for
my lord
Yes.
Item 11.
Yes.
May I please, your lordship? My lords, quashing of proceeding on the ground of mutual settlement, my lords. Yes, so a date may be fixed for the appearance of the victim and
Have you seen my judgment? Yesterday I passed the judgment. Are you covered by that parameters which I have fixed? Just check it up. It is uploaded. Huh? You bring them. You may. What are the allegations?
363 IPC, my lords.
And what is the stage of trial?
Stage of trial, my lords, I will bring all the
No,
details.
you tell me what are the whether the evidence has already been recorded. The girl's evidence has already been recorded.
No, my instruction is not there, but I will give all the details. by the
That
next
you have to
time.
see. If
Yes.
the girl has already gone to the court and deposed against you,
Yes.
no question.
No, that stage has not come. Sure.
And
That's
let us see 164. These are the two things we have to see. 164, how she is implicating you. And second is whether the girl has gone to the court and deposed against you or not. These are the two things very crucial. Bring them, let us see.
Well, my lord, I am instructed to appear, my lord, on behalf of opposite partner to.
Okay, you bring them, we'll see.
My lord.
Lordship may fix a date, my lords. Short date, my lord.
Mr. Raghunath, just check it up. Yes.
Item 12.
Yes, my lord.
FIR lodged in 420 and 468, 471, 34 IPC, my lord. The petitioner lady is, my lord. He's servicing in the school, in the district education officer and the school. And he's passed in matric, +2, +3, and he's in BEd in Chhatrapati
Lady doesn't
University.
have she has a license to commit crime.
No, I am not saying that. But he's passed all the qualification, but unfortunately he has not BEd. So that all the people of Odisha, some private BEd institution in Uttar Pradesh and Andhra Pradesh.
Take certificate.
Yes, my lord. I am going to this, my lord. So that he is not, so that
So with the certificate.
Yes.
Chhatrapati Sahu Ji Maharaj.
Yes. How can a lady from both know that it is a private university, private college, in know nothing about these things, but he has going a certificate and
What is your name? Kalpana. What is the stage now?
now
Investigation on.
investigation on, my lord.
Go and tell all these things to the police.
My lord.
Go and tell all these things to
Yes,
police. How can I?
but some problem is, my lord, and the police is searching arrested. How can you anticipate, my lord?
What are these offences? Police will not arrest.
Yes. Well, let's do direction, and I want to police and cooperative, my lord. We have no problem. Lady and he go to police. But you let's do direction, I cooperate. I have no objection, my lord.
But how can I, in 482 I pass, you are asking for something, this is not an anticipatory bail.
Yes, my lord, I know very well. But your lordship has vast power, and as per the Bhajan
Vast power doesn't mean
as
that
far
I
as
usurp the power of the other court also.
no, my lord, I cannot say, my lord. I pray on the
But in this kind of situation, police will never arrest. The allegations are very, only you have forged one document.
Yes,
for
my lord.
getting job.
Yes, but
Anticipatory file rejected.
yes.
अच्छा, rejected.
Yes, my lord. So that what
And
will be?
you want that I have to exercise the appeal power of that anticipatory bail.
No, my lord, I cannot say.
Despite that, I will have to pass an order,
No, I have a.
Show me the anticipatory bail.
My lord, cooperate, my lord.
Show me the anticipatory. Show me that order.
Order.
We'll find out some way out.
My lord, the order is 5473 of 22.
Give me that order.
My order is not,
You
my
have
lord.
that order.
Sorry, my lord, order is
On
not.
merit, whether anything is said
No, my lord, it is not merit. But it is rejected, my lord.
next week. At least you should come with the,
Yes, my lord.
all these things. Next week.
No, pass, my lord, after lunch, my lord.
You bring next week, we'll see.
That will fix, my lord.
Yes.
Item 13th.
Please, lords. Third.
ଚିତ୍ତ ଭାଇ କପି ଦେଇନାହାନ୍ତି
Instead of serving copy on vigilance
Copy
council, not
to-
copy on the state council. How do we not do it?
ଦିଅନ୍ତୁ ଏଇଟା ଦେଇଦେଲେ କଣ ସାଙ୍ଗେ ସାଙ୍ଗେ କଣ କରିବି ଆସ ଦିନ ଆସ
Genuine ground of adjournment. Next week ଆପଣ କପି ଦେଇ ଦିଅନ୍ତୁ।
ଆମକୁ ମେନସନ କରିବାକୁ ପଡିବ
ସେ ଉପରଟା କଣଟା ଏଟା କଣ
ଠିକ ଅଛି next.
Item 14.
My lord, I am on online. Your lordship may allow me on VC mode.
Yes.
My lord, may kindly turn to page 19.
19, okay.
Check was issued by the company.
19, okay. Yes.
Check was issued by SR Engineers Private Limited, authorized signatory. It's a company. That your lordship can find from page 22, which is the certificate of incorporation. The company is the registered company under the Companies Registration Act.
But see, the check is, there are many, many.
My lord, I'm coming. Your lordship may kindly turn to page 22.
22.
This is the certificate of incorporation of the register of the companies.
Yes.
The complaint has been filed against the managing director. I am governed by a judgment of this honorable court. My associate is there, will hand over. that is 2013-1 ILR Katak 906, which says if a company is the company who issues the check, the company has to be made a party. The managing
Company is
director.
necessary. Company is a necessary party.
Yes, that is my point in this case.
Where is that complaint? Show me the complaint.
Complaint petition at page 7, your lordship may see, he has mentioned Dilip Kumar Patel, occupation contractor, managing director, Isar Engineering Private Limited.
Name of
He doesn't. He has not made the company as a party.
Right. The Islamic Post Land Council of Petition submits that the issue and admittedly the issue was the check was issued by the by
Isar Engineering Private Limited.
By the company, namely Isar Engineering Private Limited, drawn by the authorized signatory on 22/9/2020, 2017.
Yes, 2017.
However, the perusal of the complaint indicates that the complainant has only implemented one Dilip Kumar Patel, who is stated to be the managing director of the company. And the company is not implicated as Mr. Bose is relying upon we can so submits that in the absence of the company being implicated as an accused, the complaint itself fails. Next, issue notice to the opposite party, returnable within 2 weeks in the Internagnum, criminal ICC number 5 of 2018, proceeding with criminal ICC also is taken. Yes.
Item 15 is also same. The criminal miscase, the case is different. Same point.
Same point where see this is another check.
Another check. Same parties are same, my lord. Only the case number will be different.
Case will be different. Numbers will be different. Okay.
The 1cc case is different, my lord.
Yes, he will check it.
Grateful, man. Grateful.
Item 16.
Yes.
May I please, your lordship? My lord, in last occasion, my lord, your lordships directed me to present the informant, my lord, because there is a compromise between the informant. With lordship's permission, the informant is residing as Asamsol, and now he is unable to come present before this honorable court. With lordship's permission, they may present through virtual mode. Yes. My lord, if your lordships kindly meet by tomorrow, my lord.
Tomorrow, Friday? Friday or Monday, whatever. Friday.
Oh, bless me.
17.
Yes. I filed the challenging that the FIR, the quashing of the FIR, that is the petitioner's wife, after filing of his civil proceeding for divorce, my lord, thereafter the maintenance is also allowed in favor of the petitioner.
You just see, you have not even implicated the opposite party.
The wife of the
wife has to be implicated.
Like,
because they are matrimonial.
Yes, ma'am.
Implicate.
Yes, sir.
Implicate and
yes.
When counsel for the petition seeks time to include necessary party in the proceeding. Again, yes.
Item 18.
Yes, please. My lord, in this LMC is quashing of the FIR. My lord, so far this petitioner is concerned, there is no evidence against him on 307, but he is implicated on this. My lord, if director, I will read the FIR. And that too, the injury is simple in nature, though the petitioner never struck him by the knife. The other party stroke petitioner simple standing and maximum 294 can be again. And my
This thing you have to argue at the stage of the framing of charges. Whether this provision is attracted or that provision is
my lord,
attracted.
actually,
At this stage, I can't.
my lord, charge sheet is already filed.
Therefore, at the stage of charge sheet, you file on the basis of whatever allegation, whatever the documents are filed, a particular offense is not attracted or attracted.
My lord, at the time of filing this,
I understand your problem because your anticipatory bail is rejected.
my lord,
I understand your problem, but I can't also.
In this honorable court, first, at first, just giving a
I know
two orders that
interim order was passed, no courtship action. I just
no
courtship action.
my lord,
Thereafter, when it
and
was finally taken up, it was dismissed.
ask for injury report also.
Whatever 307 is there and everything is there.
307, my lord, if I go to the FIR, there is no act.
Try to understand on the basis of FIR, I can't decide whether 307 is made out or not. Isn't it? So therefore, it is the only appropriate stage would be for you to argue at the stage of framing of charges.
My lord, charge sheet, if already charge sheet is filed.
That's the reason I'm saying. Now charge sheet is filed, then you have to go to the right forum. I can't just see the FIR and say that 307 is not made out.
No,
charge sheet is filed.
just it, as per FIR, it no 307 will be there against the petitioner. That's
how can I examine it? Right?
No.
Yeah, I can understand your problem, but I can't help you. That's the problem.
My lord, pending this directed to submit the charge sheet.
There is an order already. One coordinate bench says no 438, no offenses. I can't grant anticipatory bail. How can I supersede that order?
So I am not.
Any order I pass, amounting to superseding that order. I can't do that.
This honorable court is also going to.
We have to respect the order of.
No, I am not saying that. But
I can't possibly help you.
Charge sheet.
You may be entitled for bail.
Charge sheet there.
But it will serve no purpose. Rather I'll give you the liberty. You go and argue all this. Proceed further. And you know the remedy against the anticipatory bail. Unfortunately, you have not got it. What to do?
Up to charge. Charge sheet. Charge sheet.
Charge sheet remedy is filed out. When it comes about the petitioner seeks to withdraw the petition to resort to the appropriate remedy available to him under law at appropriate stage. With this liberty, the petition is disposed of. You challenge this order, you will get the bail. This is my personal view. I don't know.
Item 19.
Yeah.
Yes.
Mr. Malti. Lordship, here I am challenging the order dated 2/3/2024, while the Honorable Court below has allowed the petition under Section 457 of CRPC by imposing the condition of 66,000 toward the expenditure regarding the cattle maintenance and 2 lakh.
Same problem.
2 lakh.
27 lakh.
They go, yes, man.
He is the owner of the vehicle, and that vehicle is a goods carrier vehicle, and his livelihood depend upon that vehicle. He's a poor person, your lordship. He cannot pay such huge amount.
That's right, but what to do?
Lordship,
you indulge in smuggling the cattle. Cattle were seized.
Lordship,
and now it is given to some Gosala. Who will bear the expenses?
Lordship,
11-22-22-24.
Yes, Lordship. Lordship, one similar order has been passed by your Lordship in CRMC.
200, rightly. 200 into 3 into 110.
Yes,
equal to 66.
That Lordship, Annexure 2 is One similar order which is squarely applicable to this case passed by this honorable bench, that is in CRLMC number 3539 of 23. The ratio has been calculated at 50%. Your lordship may kindly see the page number 19 and 20.
So you rely upon this, it says, see, in that order, what this court has done is
That's a
total amount of 6 lakhs.
yes, 6,75,000 something, some odd.
Have you shown this judgment to the trial court?
No, lordship. But trial court has taken consideration of that.
Right. I'm giving that liberty. You right.
Lordship,
Why
the amount will be modified to some extent.
petitioner is impugning the order dated 2/3/2024, whereby his application under section 457 CRPC has been allowed. However, the same was made conditional. So the petitioner was directed to deposit 66,000 rupees. 66,000 rupees. Then, consequently, the petitioner is relying upon a judgment of this court passed in CRLMC number 3539 of 2023, and submits that the conditions so imposed by the court below may be varied on the basis of the same judgment. It is apparent from the record that the same judgment was not placed before the court below. Therefore, the petition is disposed of. We can negotiate with the petitioner to move an application for variation of the condition before the court below on the basis of the relied upon judgment. With this liberty, the petition is disposed of. I have mentioned it to move the application to rely upon the next.
Item 20.
Praise the Lord.
Yes.
Your Honor, Annexure 1, I have filed a petition on 311 CRPC to recall the PW4 with the eyewitness and informant in the case with some questionnaire. My lord, last time they will examine PW4. Only that period. Any date may be fixed, my lord.
What is the offense?
302 along with the other offences. With the evening incident took place, the evening hour. So, my lord,
why didn't you ask these questions?
some question has been left. That's why lawyer have been changed, my lord. And last chance,
22 charge sheeted witnesses, my lord, the 19 witnesses has been already has been examined, my lord. And this PW4
Only-
my lord,
only-
also has been examined, and after long gap, now he has filed
Where is the order?
11
Let us see the order. What?
my lord, page 13, bottom portion, page 13, my lord, bottom portion. On the perusal, it is found that the accused facing trial 302/34 IPC. Now, the case stands posted trial wherein out of 22 charge-sheeted witnesses, 9 charge sheets have been examined, who are the material witness, including the informant. On perusal of the evidence, it is found that most of the
2006 the
let us
PW4 was
split off ହେଇଛି case ଟା. That has been split off. So any day may be fixed, and I will bear the cost also, my lord. But once because he is the vital witness, PW4 lawyers have been changed. Your lordship kindly
What
say
is the age of this PW4?
age, my lord. Age, my lord, 35.
Now.
Now, my lord, at the time of
Because 2006 you have examined. Now you move this application.
it is split off case, and subsequently warrant has been issued.
2023 you moved application.
Because laws have been changed and I have voluntarily surrendered.
Change means
And also I have surrendered.
wiser lawyer, wiser question.
Yes, sir.
Keep on changing,
And-
keep on moving up.
And last and I will, my lord, bear the cost of the, so only once a day also may be fixed. My lord.
What are the questions that are?
I have given, my lord,
What are
page
the
10. ନାଇଁ ନାଇଁ ଅଛି ଅଛନ୍ତି ନା ଆମେ
meantime 24 years are already passed.
ନାଇଁ ନାଇଁ ଅଛି ଅଛି lordship.
I leave your
ନାଇଁ, I leave-
Let us see.
on
Because
that
the
ground
time
matter
has
will be
left.
continued.
And it
No,
is
my lord,
obvious-
till-
it is obvious that
No, my lord.
these witness
Yes, there, temperament is there.
he may be there. Obvious that he might have forgotten everything. You take
No,
advantage
he
of
is
that.
the informer because he is the brother-in-law. The disease is the brother-in-law.
Decision is
The
that
disease is the
only in
brother-in-law.
order to fill up the lacuna.
No, no, that is a split up.
That your
And I have
lordship
made the
Where
questionnaire.
is split up? Nothing is there on
And
record.
your lordship kindly see, these are the question I have, she reject kuchundi, some
Now,
question.
in so far as your case is concerned,
Yes, madam.
in 2006 he was examined.
Yes,
There is no
madam.
doubt about it.
Yes, madam.
Maybe split up subsequently. 2006 to 2023, why have you not moved application? You explain that.
And
At the late stage, why are you merely because a lawyer change? That cannot be.
and my lord, subsequently,
Come to your application.
my
The
application is
you
page
don't
10,
change.
my lord, page 10.
I'm there.
Yes, my lord.
There are relevant questions which are very important after application of response. At what time you reached? Where is this statement? Show me. Let us see. Where is his testimony?
My lord, questions are there.
No. Where is his testimony? Whether these questions were put to him or not?
Arjun did.
Where is that testimony?
Yes, my lord.
Where is that?
I'm giving my lord.
You will not file that. You place on record that. When a consequent business seeks time to place on record the testimony of PW4 to substantiate his case. Substantiate his case under section 311 CRPC. Yeah. The PW4 was examined in the year 2006, whereas the application under section 311 CRPC was moved in 2023. 23. Therefore, he has to. There is no explanation why the application was moved belatedly. You explain that also.
My lord, because warrant has been issued, subsequently I surrender. My lord.
The constitutional petitioners think time to file a better affidavit to explain it. File the affidavit.
And my lord, so I filed adjournment petition just one date. So for my lord, because the
Warrant issued again?
no warrant, no. Your lordship, that case has been posted to my lord 25th.
For what?
For my lord, evidence, further evidence.
Further evidence, let it go.
My lord,
What was
otherwise,
the
my lord, evidence will
19
close.
See, there are many witnesses, they will be
Only
examined.
one adjournment.
No, why adjournment? The other witnesses may go on. You are interested in PW4. He
Only
will be called. How does it make difference?
and only that I will also be.
Why should you ask for adjournment? Why? For good reason.
Because of the.
You want examination of PW4. Witnesses are being examined. In one day, what will happen?
Well, that is for defense witness.
Still, nothing will happen. Let them do it. No problem.
Yes.
Why should you stop? First of all, you file application after 24 years.
Well, because my lord, warrant has been issued, I have surrendered subsequently.
That is, those things are not relevant. In 311 application, you want.
Well, only pay one adjournment.
No.
I will file that.
You
will be
file affidavit and bring on record. That was so important a document.
Yes, my lord. Yes,
without seeing me.
My lord, I will file.
Testimony of
Yes, my
PW4, you want
yes.
to recall.
Yes, my lord. Yes,
that is the only document you are supposed to file.
Yes, my lord.
You didn't file that.
No, I will file.
File it, we'll see.
Fix a date.
A date is there. Date. See, these are minimum things you should file. 21. Yes.
May I please, your lordship?
Yes.
The petitioners challenge the cognizance order dated 3/7/2020 for the offence under section 341, 323, 294, 506 by 34 IPC, and also under section 31.
Yes.
2B of SC Act.
What are the ground?
Case and a counter case. Our case is first.
Where is the charge sheet?
Our annexure 2 is our case is case number 6 of 19. Is another case is case counter case
No, I am searching the charge sheet of your.
Charge sheet on
Yes,
dated
yes. Charge sheet is
3
there.
7/2020
17, okay. You are Mr.
No.
Topon Samantray.
Yes. ଆମ ଝିଅ 14 ବର୍ଷର ଝିଅ ସ୍କୁଲକୁ ଯାଉଥିଲା ତାକୁ ବାଟରେ ଘେରିକିରି ଏ ଯୋଉ ମିନତିର ପୁଅ ରାଜେଶ ମଲ୍ଲିକ ସେ ତାକୁ କମେଣ୍ଟ ପାସ୍ କଲେ ତାକୁ ମାରଧର କଲେ ସେ ଆମେ ଏତଲା ଦେଲୁ ତାପରେ ସିଏ ଆସିକିରି କେସ୍ ଦେଇଛନ୍ତି SC/ST ଆକ୍ଟ ତେଣୁ ଆଗ୍ରେସିଭ ମୁଡରେ ଆଉ ପଲିଟିକାଲ ରାଇଭାଲ୍ସ ଏଗନେଷ୍ଟ ଅସ୍
So these things, how can I analyze at this stage?
Yes.
At this stage of cognizance, how will I arrive at a conclusion that it is because of the enmity, whatever?
Victim not examined till yet.
Huh?
Victim, that is OP number 2 is not examined till yet.
Sorry, I didn't follow you.
Yes. Victim is the informant of you.
Maybe, but how will I at the cognizance stage? How will I? Can I conduct a trial?
It's a preliminary stage, man.
Very preliminary stage. It can't possibly help you because it is very. See, there are two FIR. I don't know which FIR is correct. What?
Our FIR is fast. The counter FIR.
Where is the charge sheet in against you? Which is the
charge sheet?
Where is the charge sheet?
Filed here. Annexure 1. Annexure 1.
What charge sheet?
It
खाली कॉपीटा तो फाइल है जिदे चार्ज शीट नंबर 36 डेटेड 13/2/2000
it all the papers all the total copy
नहीं put
देखिए
कितने कौन
page number 11 to 41
11 to
41 एकाथरे कॉग्निजेंस ऑर्डर और चार्ज शीट सब नहीं आछन एकाथरे
reading the charge sheet you will find that some allegations are made against you and serious allegations are made against you. Rightly cognizance is taken. Rightly cognizance is taken. What is wrong?
Second counter FIR is also false.
Maybe counter FIR. On the basis of that counter FIR, I can't quash the cognizance order. I have to, in a cognizance order, I have to see whether in the charge sheet any prima facie case is made out or not. Beyond that, I can't see here and there. So therefore, in the charge sheet, allegations are serious allegations are made, and therefore the cognizance is rightly taken. I can't see beyond the charge.
Purely false allegation.
Maybe you may be correct, sir. I can't see beyond the charge sheet at the cognizance stage. Why don't you appreciate? Right on. When counsel for the petition seeks to withdraw the petition to raise all these points at the appropriate stage of
second case will be charge sheet
court below with this liberty the petition exists.
22.
20.
Yes. I please, your lordship. Let's see here, the petitioner has prayed for quashing of the proceeding where the offense alleges under section 468, 471, 420, 34 IPC.
Yes.
So for the allegation against the present petitioner is that while entering into the IOCL gate at Paradip, gate number 1, he along with 4 other persons were checked by the personnel, those who are in the gate. And it is found that 4 numbers of gate pass are forged one. And it is also stated against the present petitioner that petitioner is doing such forgery, preparing the forgery gate pass. And petitioner was arrested on 8/7/2021. And he has been released thereafter on 13/7/2021. Charge sheet has been submitted. And here also the petitioner has been substantially punished because of the act. And is a young person of 28 years.
How substantially punished?
Punished by remaining in some time in the jail custody. From
So then the complicity is further proven.
yes,
Because you were taken into
Lordship,
custody.
no, no doubt
How,
he's
is that any ground for quashing?
no doubt he's in.
He has confessed before the authority.
No doubt he has confessed before the authority.
On the ground of sympathy, I can't quash. No?
No, Lordship, sympathy is a year 28 years of old.
That's right. But
And
what can I do?
a young person at the threshold, he has been punished because of his act. And your Lordship may see the cognizance has been taken in the meanwhile. And so far the service and job is concerned, your Lordship is well aware that verification, police verification and other things are there.
You have created.
Once he has made a mistake.
Created duplicate seal.
Yes.
Of CISF.
Yes, that is
How
there.
dangerous it
That
is?
is there. That is there, no doubt.
The CSF and the signature also concerned officers.
Signature CISF is
Yes, that is there. Your Lordship may
dangerous.
the plight of the your Lordship may see the petitioner is a 28 years old and is
On the sympathetic ground.
for the
nothing
job
can be done.
he has to suffer for the all along his life.
Creating the seal and everything.
Yes, no doubt, Lordship.
For
That,
the signature
that
of
is there.
CISF officers.
ସେଥିପାଇଁ
That
ସେ
is-
ପାଞ୍ଚ ଦିନ
It's a
ପାଞ୍ଚ
matter of security.
yes,
It's a matter of security.
secret.
You can't be.
Lordship may see is nowhere and nowhere in employment also.
But the petitioner seeks to withdraw the petition to read all the point at the appropriate stage before the trial court. With this liberty, the petitioner is disposed of. You argue at the stage of charge.
No place.
23.
23 for a passover, your Lordship. Mr. On behalf of Mr. Mishra.
Passover. What those group matters? Yes, those group matters.
Yes.
You tell me the date and
13.
13.
That is agreed.
At 13.
That may say 2 p.m. so that it can.
2 p.m. 13.
Not that
13th of May. 13th May.
Interim order-
Entry order to continue in all the matters.
The Lordships have passed some entry order yesterday. If that can be granted in other cases. Subject to my learned friend agree. I don't want
13th,
to.
all the entry order, similar entry order.
13, 2 p.m.
2 p.m. Okay.
Okay.
Yes.
23.
23. 23 টা passover কম। 24.
24.
24. Lordship, 23 not a passover. Mr. Mishra has told.
Yes, pass.
So far 24 is concerned.
Passover.
Your Lordship, here the petition has prayed for quashing of the proceeding, and the Lordship may kind of a glance that the offense under section, Lordship, the fact remains that for disruption of power supply, more than 200 people along with the present petitioner.
Is it 24?
Yes,
I think
the item is 24.
Okay.
Lordship, so for the disruption of the power supply, 200 peoples of Sarandapalli under the Barpali PS घेर out the 33 by 11 kV line at Sarandapalli, and with and in this regard, the FR registered under section 147 of 48, 333, 353, 294, 506.
Kanu,
Let's-
Nirmal Acharya, where are you figuring in?
Yes, Nirmal Acharya is one of the accused. He has been implicated in this case.
Yes.
But so far the injury is concerned, they have stated is a grievous injury in the neck. But your Lordship may see in the FIR, page 16, page 16, your Lordship.
Yes.
Just 1, 2, 3, 4 paragraphs, just 2 lines from the 4 paragraphs. After radiology examination, Lordship got it.
Yes.
I was shifted, sorry, 1 line from the top. I was shifted to Vikas Multi-Speciality Hospital for further treatment. After radiology examination and consultation with specialist, I was late to go from the hospital after 4 hours with an advice to report tomorrow for further investigation. This is the grievous injury they have stated in the neck and in the notes. But no here stated who has out of 200 persons, how can
147,
how can
148 mob.
yes
Who has beaten
who
all
has
these things?
no
how can-
specific allegation against me, but I am still suffering.
If a mob goes,
Yes,
nothing can be.
somebody has
attributed
pelted a
individual.
stone, but the for that person all are suffering.
But the petitioner was absconded since long.
It's-
That's the problem.
Yes, NBW has been issued.
The problem is that it is a mob, 147, 148, writing and all.
And charge sheet has been submitted and NBW has been issued against the present petitioner. Your lords may see at annexure,
Yes,
page 46.
46.
Yes, your lords.
46.
46, the NBW has been issued, order dated 29/9/2023. The record is put up today on receipt of the prayer of allocation of the IO for issuing NBW against the accused persons, so and so. Let's say my name is serial number 6, Kunu Acharya alias Nirmal Acharya.
I'll stay. Go and appear.
That's it.
That is the best thing I can do.
Let's.
Yes.
I'll stay.
Let's.
Right. The petitioner is an accused in one of the accused in FIR number 2. After investigation, charge sheet has been filed on
Charge sheet has been filed on
Lordship. 1/12
Lordship on 1/12/2023.
23. 23. Since the petitioner and the other accused persons were absent when the matter was taken up, the JMFC Burville, by order dated 29/9/2023, issued NBW against the petitioner and other accused persons. For next one, the petitioner is seeking quashing of the entire criminal prosecution launched on various grounds. I'm not inclined to entertain the petition at this stage. However, liberty is granted to the petitioner to raise all the points at the appropriate stage before the court will. Insofar as the next program, insofar as the issuance of NBW is concerned, the operation of the same is set aside. The NBW issued by the court, issued by the JMFC Burville on 29/9/2023, the same is set aside, subject to the petitioner appearing before the court on or before 5th of May. I'll give little more time.
Lordship, more time, it's a politically involved person.
Tell me the date.
Politically involved person.
You tell me the date.
Lordship, after the election, 14th, after 4th of June.
41st May.
No, he is a
political person. Probably Devesh Acharya. For Devesh Acharya, he's
15th of June.
15th of June.
15th of June. Because this is mob and all.
The work is related to mob.
June.
Obliged.
And who knows, you may be a minister also by that time. 15 June, honor to 15 June, and move appropriate application seeking remedy under law. This liberty is
I am obliged.
25.
25. 25. Yes. 25?
Yes, madam.
Yes.
My petitioner is retired in the year of 2012.
Yes.
Page 24, mine.
40?
24.
24. What are you challenging here?
My lord, I am challenging that the NBW was issued regarding violation of Industrial Dispute Act. One prosecution report was filed in the year of 1994. 95. He was there for the short period. Even though at that time of the filing of the prosecution report, the name of the accused was mentioned as him. That is, the petitioner is the name of the accused in that case. So in the meantime, when initially NBW was issued, page 20, my lord, page 20, my lord.
20, okay. Yes.
Initially NBW was issued, he appeared and released another. Gone. Thereafter he retired. No, prior to retirement, thereafter, due to non-appearance of advocate at Balangir, again NBW was issued. Once the NBW was issued, the advocate thereafter filed the petition to recall the NBW. That was not recalled. The petitioner was at that time in service. Filed a CRLMC here, but that record is not available. CRLMC here. There was a stay. But my lord, page 22.
What do you want?
My lord, let me finish, my lord, something there. Page 22. The order was, the petitioner to go to Balangir and see and produce the document that a award has been implemented. That is the case. But the petitioner has retired. The advocate conducting the case has died. The case was pending there at Balangir for 10 years. My lord, in the year of 2021, page 24, NBW was issued. NBW was issued to the Bhubaneswar PS, capital PS. The capital PS also did not execute. When the election, ensuing election, the old pending NBW were being executed, he was asked to surrender. But he is unable. Heart has been operated. My lord, only submission is that sufficient time he cannot go individually to the Balangir. And also in the ensuing election, there the hotel accommodation also not be available because of the political contest.
Yes.
The date may kindly be substantial time may be given. He will go there, appear, and produce the document. That is my submission, my lord.
Okay, you tell me the date when you want to go.
My lord, election will be over after 15th. Sir, at
See, same 15th June I am giving.
My-
The earlier also I had given 15th.
Yes.
You are 70-year-old.
Yes.
Okay. Where is the NBW order?
21 कौन कौन से छुट्टी थी बताओ तलकोट छुट्टी
NBW order dated.
NBW order my lord. Yes, my lord, page 27.
20?
27.
27. Yes. 27. Passed by the order dated.
Order dated 27. Order dated 27/1/21.
The order dated 27/1/21.
27 January 21.
Nothing is visible anyway.
This is
22nd January.
22nd January 21.
21 passed by SDJM
Balangir.
in
I say 2CC case number 2 of 98.
98. The operation of water gate. The operation of water gate so issued by so and so in 2 cases shall remain.
अरे withdraw कर दो तो पारे बरंग तापर NBW may be withdrawn thereafter.
Satisfied, subject to the condition that the petitioner shall appear before the state court on or before 15th June 2024 and moving appropriate application before the state court under the provisions of law, under the provisions of the petition on the aforementioned terms, the petition is disposed.
Obliged, madam.
I guess.
And POCSO Act. In this case, already we have married between the parties. Opposite 3 along with myself. And on the basis of the allegation, I have been arrested. Now he is in custody. So matter has already been compromised between the parties.
The informant is
Mother-in-law. Mother-in-law.
I have been instructed to appear for the copy number 2, the mother of the victims.
Yes.
So I will appear. I will file the power.
What is your instruction?
So my instruction is now both the parties are agreed to settle the problem. So then
have they married?
Now the girl is carrying 6 months.
6 months.
She is pregnant.
Pregnant.
Through this boy only.
Oh, yes, madam.
They're not.
There is no question of disputes regarding
Why you are not getting paid?
Bill, I have already filed 437 application before the court below.
He is in custody. Unless he comes, then we can't pass it.
And London court below specifically said that unless only charge sheet has not been filed, I will not
Charge
grant.
sheet has now been filed.
Under investigation.
So
Let them out from the custody. Then you bring that girl here, and the accused has to be there. Then we'll quash it.
One thing I will pray, my lord, you also may direct the court below to consider my bail application in view of the compromise between the parties. then only then London Court below can consider during pendency of the charge sheet.
Where have you said that she married and in a
Well,
case-
already I have
What is this horoscope you find?
horoscope because the age they have mentioned 2007 as per application. So horoscope 2006 my lord.
But
So-
at the time of occurrence, it was 16.
So allegation is there, but
Now you are
already
going to
attained
marry-
majority.
You are going to marry.
Already married in the temple my lord, and they were residing there at Nayagad.
Where is 164 statement?
160% just I'm placing page
161, 161.
page my lord 23 20 informant statement.
Just see. It's not informant. Talking about the girls. Whether
164
was recorded or not?
Recorded, but
Where is
164 equal with the 161 statement. I have not that record, but 161 statement is there. You will also kindly have a glance page 24 of the victim
Yes,
card.
read
My
it.
wife.
Read it, read it.
Married.
Not wife, the victim's statement.
ବର୍ଷା ରାଣୀ କାରୁଆ
ମୋ ନାଁ ହଁ
ବର୍ଷ 16 ବର୍ଷ ପିତା ମୃତ ଧ୍ରୁବ କାରୁଆ ଘର କାଠଯୋଡି ବିହାର ଶୁଣଛୁ ମୁଁ ମୋ ମା ଦୁଇ ଭଉଣୀ ଓ ଗୋଟେ
Yes, ma'am.
This affidavit?
Yes, ma'am. This
Yes.
way. Personal.
Annexure what?
Annexure, yes, my lord.
Yes.
He is a reporter, my lord, of the daily newspaper Sambat, my lord.
Yes.
And he has published some news articles that is Muribal Thana Constable Karnama Thana को दियाउथवा गोपन सूचना अभियुक्त को मिलुची. Next, my lord, दादन जाई सब हुई फेरिले बनिता. Next one, थाना भीतर युवक को माड़ उभय पक्षरु एतला. These are the cause, my lord, because for which a false FIR has been registered against the present petition.
But what are the when dates are May?
In the January, my lord, in the month of January, then September, repeatedly, my lord, there is October
Okay.
and September.
Okay. The affidavit is already there on record.
Yeah.
The petitioner has filed the
Additional affidavit.
My lord, the FIR allegation there is no connection with this affidavit, my lord. FIR allegation is separate, my lord.
No, that what he says that because these articles he is a journalist.
Yes,
Because
my
of the
lord.
consistently he is writing against the police. Police has implicated him falsely. That is what his case.
Yes.
That is what his case is. If what is the what are the allegations in the FIR?
My lord, that is under 34, 379, 427, 506.
Charge sheet is filed. No.
No, no.
ସମସ୍ତ ବ୍ୟକ୍ତି ଗୋଟେ ଜେସିବି ମାଟି ଗୁଡା ପତ୍ର ଯାର ନମ୍ବର ହେଉଛି ଏତେ ଉପରୋକ୍ତ ଯନ୍ତ୍ର ସାହାଯ୍ୟରେ ମୋର ଘରକୁ ଭାଙ୍ଗି ପକାଇ ଘରେ ଗଚ୍ଛିତ ଥିବା ଘର କରୁଣା ଜିନିଷପତ୍ର ଯଥା ନଗଦ 3 ଲକ୍ଷ ଟଙ୍କା ଦ୍ୱିତୀୟତଃ ସୁନାର 1 କୋଟି କାନଫୁଲ 1 କୋଟି ତା ସହିତ ରୂପା ଅଳଙ୍କାର ସହିତ 2 ଗୋଟି ବଡ ବାକ୍ସ ଯାହାକି ତହିଁରେ ଘରୋଇ ବ୍ୟବହୃତ କଂସା ବାସନ ରହିଥିଲା ସେ ସହିତ 2 ଗୋଟି କୁଲର ଖାଇବା ଚାଉଳ ଅରୁଆ ଉଷୁନା ମିଶି 10 ପ୍ୟାକେଟ ଚାଉଳ ନିତ୍ୟ କାର୍ଯ୍ୟ କପଡା ଲତା ପୋଷାପତ୍ର ସବୁ ନେଇଯାଇ ଅଛନ୍ତି ଯାହାର ଆନୁମାନିକ ମୂଲ୍ୟ 7 ଲକ୍ଷ ଟଙ୍କା ଜିନିଷପତ୍ର ସରଞ୍ଜାମ ହୋଇଛି
As if he is a thief, my lord. And previously his mother has first given the FIR, my lord. That is page number 13, my lord. Can I read out, my lord?
Yes.
ये गत 23 वर्ष पूर्व मु रहतो आस स्थान रे लिखित कारण एमति कि जे मु बनिता महाकुर स्वामी स्वर्गत स्वप्न महाकुर गांव मोरीभाल उरे बलांगीर बासिना रे गत 23 वर्ष पूर्व मु रहतो आस स्थान रे पछ
I just issue notice. Let us see.
Yes, ma'am.
I issue notice. Because there are complications.
Yes,
Journalist is
yes,
there,
yes,
he
ma'am.
might have-
And not to arrest, man. No coercive action. No, not to arrest. The election is there, Mala. Keeping in elections, Mala, in the mind, these things is a police official. Particularly this opposite party number 3, he is doing such type of methods activities in that locality, Mala.
You have applied for reduced bail.
No, no, Mala, not applied. Not applied, Mala. So I have to be protected, Mala.
No coercive action is so dangerous at this
Yes,
stage
Mala.
that
So
for
not to arrest.
investigation
Not to arrest,
ideally-
Mala. Actually, not to arrest. Because I'm a press reporter, Mala. I'm having some name and fame in that locality, Mala.
Shall I record your statement that you will inform the police not to arrest?
Yes,
Because
yes. No, no, I will inform to the police.
No such allegation.
investigation is going on.
Yes, my lord, but
I can't
no,
stop the
no such type of serious allegations also, my lord. This is totally fabricated to only to harass the present person.
That's right, but how will I know?
Yes, my lord.
How will
My
you
lord.
may be involved, may not be involved.
Yes, sir. Let the investigation go
I
on.
can't
let them-
exercise 438.
Yes, my lord.
438 I can't exercise.
Yes, my lord.
I can't stay the investigation.
My lord.
What else I can do?
So, my lord.
Only I can issue notice and
Notice-
request them not to do
No,
anything.
not to arrest. At least up to
Not to
completion.
arrest is an order under 438.
No, no,
I am
no.
exercising 482.
Only to protect my lord until the election is over. It is keeping in mind.
Whatever, but that is in the nature of 438.
My.
I can't exceed my
Yes, ma'am.
jurisdiction.
Yes, ma'am. I have to protect the just because I'm unable to move.
What to do?
I will inform to the concerned IS, my lord, regarding the.
Give the affidavit. The when it comes for the petitioner has filed an additional affidavit, enclosing various articles he has published being a journalist against the police. Against the police. The articles are also placed of record into this affidavit. And he interiorly states that on the because of the articles he has written exposing the police, has implicated him in the present case. Present case. Issue notice to the opposite party 2 and 3. 2 and 3 returnable questions. Mr. Rahul appearing for the state submits that the investigation is going on in the present case. And he will suggest the IU of the present case to issue appropriate notice to the petitioner. Petitioner if he is needed for the investigation. Investigation. This is the matter. You tell him to issue notice.
Published.
Immediate.
Tell him to issue notice.
Yes. Original certified copy.
28.
For item 28, I beg your lordship's permission to address. I am on BC.
Yes.
Now, Lord, it's a revision against a summoning order, which lordships will find at page 38 as Annexure 1.
58.
38, Annexure 1.
38.
Yes, my lord.
38, yes.
Now, Lord, this is a private complaint case in which on 22nd of February 2024, Lord, the learned magistrate takes cognizance, examines the complainant, examines a witness, conducts an inquiry under 202, and issues a summon against, Lord, two gentlemen, Lord, whom your lordships will find at page 39, to appear in response to a summon, Lord. Lord, not a shred of facts is discussed. There is no satisfaction which is indicated in the order that 420 or 406 or 409 is made out against any of these individuals.
Yes.
Lord, if your lordship sees the complaint, which is the basis for this summoning order, which your lordships will find at page 39, Annexure 2.
Yes.
It is directed against two individuals, my lord. One is the assistant vice president of a company called Flowmore Limited, based in Gurgaon, Haryana.
You are referring to?
No, I'm appearing along with him.
Okay.
And one of the second is the chief executive officer of the same company, Flowmore Limited. Again, he's based in Gurugram, Haryana. The company itself is not made an accused. That's the strange bit here, my lord. And my lord, why I say so is if your lordships turn to page 41 for a moment.
41.
Yes, my lord. That's where the allegations start flowing.
Yes.
Para 2, Lord, he says that the accused persons are the employees of Messrs. Flowmore Limited, Gurgaon, and are involved in this case, that the complainant issued 2 purchase orders dated so-and-so for purchase of pumps, of which the deliverable period was 60 days. That subsequent to the aforesaid purchase orders, there was a requirement of another pump on urgent basis, and the order was placed on 17th March 2022. Para 5, that in view of the above purchase order dated 17th March 2022, the accused number 1 demanded advance payment, and for which the entire amount of purchase order along with 2% extra cost for packaging, transporting, forwarding, and miscellaneous charges amounting to so-and-so was transferred and paid by the complainant to the HDFC bank account so-and-so of accused number 2 with the knowledge of accused number 1 for the purchase order dated 17th March. And the said amount was received by accused number 2 on dated so-and-so, 21st of March. Lord, that's a wrong assertion. It's the company's account, not the chief executive officer's account. Para 6, that after receipt of the said amount, the accused number 1 informed the complainant that the other two pumps, bid purchase order number so and so, that is 25th February and 7th March, were ready for delivery and along with the pump of the last purchase order, and requested the complainant for full payment of the 3 pumps amounting to rupees 1.66 odd crore, to which the complainant shown its inability to pay the entire amount, and that amount due to financial constraints. And since the deliverable time of 60 days had already completed from the date of the order, and the accused persons insist for payment of the entire amount to the complainant, the personnel of the complainant wanted to inspect all the pumps of the factory workshop of the accused persons so as to confirm the position of the delivery. But neither the personnel of the complainant were allowed to inspect the pumps at the factory of the accused person, nor processed in sending the third pump bid purchase order 17th March. Now, my lord, please see this with page 80. It's a completely false assertion.
No, come to para 10.
Yes.
My client issued the previous notice.
Clear notice to accused number 2 on 12th of June 2023 to refund the entire amount of 31 lakhs.
Basically, order was placed for purchasing 3 pumps, which was not delivered by you, and they issued a notice for refund of that money. Thereafter, the complaint is filed.
First 2 purchase orders have been cancelled by him.
I'll issue notice. This is a commercial.
It's a completely civil transaction, my lord.
Issue counsel for the petitioner, Mr. Manu Sharma, along with Mr. Amit Patnaik, appears for the petitioner. The counsel for the petitioner submits that allegation. The present case is arising out of a complaint, 1CC case number 32 of 2023, on the allegation that the informant, the complainant, had placed orders for purchasing 3 pumps by paying the consideration amount. It was supposed to be supplied within 60 days. Since the pumps were not supplied, the complainant issued a notice, legal notice, through advocate for recovery of the entire amount. Should that the complainant has filed the 150 case instead of resorting to recovery proceeding, which indeed he has initiated by giving a legal. Is notice to opposite party number 2. Opposite party number 2, na?
Party number 1, Lord, because it's a private.
Completed or not?
Yes, Lord. The state is not a party, Lord.
What is this? Everything you have written in handwriting only. Chitaranjan Das is the petitioner.
That's the petitioner, Lord. And Damodar Saw is the complainant who acts for the company SMC.
Write down, Mr. Patnaik, what is this? Just see the petition. What have you written?
Extremely sorry, Lord. It should have been.
Please on record a typed copy of this.
I will do that.
I can't make out anything out.
It's the address given. I will do it right away.
Respondent who is what?
I will do it right away.
Type it out and.
I will do it right away.
Is notice to opposite party number 2. Returnable within 2 weeks. In the meantime, the proceeding in ICC case number. What is that case number?
32 of 23.
32 of 2023. Pending before JMFC cognizance, JMFC 1 cognizance taking
Court.
Jharsuguda.
Yes, ma'am.
Isn't it?
Yes, ma'am.
Let's take till next appeal. Yes. Next.
Deeply obliged, ma'am.
So grateful.
Yes.
The petitioner seeks to challenge the order dated.
Your Lordship will state that order. I'm so sorry, Lord, that the order taking, sir.
Yes.
The proceedings have been stated.
Yes, I have stated the proceeding.
Sorry.
Yes. Yes.
31 million.
Yes.
The petitioner seeks to challenge the order dated 20th August 2000. Belgium.
You tell me when you are on bail. 2007.
Bail to 27/6/2003. 3.
And NBW?
NBW was issued 28 August 2007.
20 August 2007.
7.
ठीक है, क्या जरूरत है?
city
Give
case
1,000, yes.
yes
32.
Yes.
Challenging the entire criminal proceeding. My lord, initially FIR was lodged under section
ଆପଣ ଛୋଟ ମୋଟ କାମ କରନ୍ତିନି ପୁରା କ୍ୱାସିଂ ଖତମ
493, 417, 376, madam.
376
My lord.
ground.
Ground, my lord, both the offenser, if it is 493, then 376. Need both offenser.
No, either 376 or 493.
49. Yes, my lord.
That's not your case.
That is my case.
And then you go and argue on charge.
My lord, I have already taken that.
What is the charge order? What is charge is?
My lord, page 25.
Oh, 227 you moved.
Moved.
Which was rejected.
Rejected. And on this same day, charge was also framed. And I have earlier come before
Yes,
your
Mr.
Lord, I have earlier come before your lordship. One case dismissed for non-prosecution. Our other case was I have withdrawn.
Withdrawn to approach.
My lord.
Then thereafter you filed 227.
227.
When this order was passed and charge is framed.
My lord.
Ideally, you should file a revision
My
petition against this order.
My lord, on 6/3/2024.
But revision should have been the ideal, proceeding. Because charge against charge.
I am not, for that reason I have, my lord,
There is
my
227 order also.
Yes, sir.
Anyway, so yes, Mr. Rahul, how do you sustain this? Either 493 or 376?
My lord.
So both the charges are framed.
Yes, my lord. 493, 37.
Either 493 or this thing.
Yes, my lord.
Higher offense is 376.
376. 493.
I'll drop 493.
493 tribal magistrate.
So I'll drop that. Higher offense has to be there, obviously.
My lord, if you go through the allegation, my lord.
But see, I have to drop 493 because higher offense has.
If both will run well together, then there is chances of acquittal.
Unnecessary you are creating problem. Conflict with how ever kind clear କରୁଛନ୍ତି confusion ଥିଲେ benefit of doubt ରେ ଆପଣ ବାହାରି ପଡ଼ିବେ I'll give you that liberty to raise all these points at the appropriate stage. Keep it open.
With that observation, your lordship.
Yes. Keep it open that you get the benefit. Right now. The petitioner is challenging the order dated.
I am not. I am challenging inter-criminal proceeding.
The petitioner is assailing the entire criminal prosecution initiated against him on the ground that he moved on the ground that charges has been framed against him. On the ground that he is put to trial for offense under section 490 under section 493/417/376 of IPC. He submits that he moved an application under section 227 CRPC, which was turned down by the court by order dated 6/3/2024, and the charges have been framed. Mr. Tripathi, Land Counsel submits that the two charges which are framed against his client and subjected to the trial, are running contrary to each other. I'm not inclined to interfere in this matter at this stage. However, liberty is granted to the petitioner to raise all these issues at the appropriate stage of the trial. With this observation, the petition is disposed of. You raise, you will be acquitted, but that's a better idea.
Sometimes, manager, for professional this case to file. Professional.
I know. Right. 33.
This is the Belgium matter. The petition is in bail matter in 30
Yes.
for 2015. That was NBW issued on dated 17/5 to 2018, my lord.
17/5, 17/5 2018 is NBW and bail
Bail was 13/4/2015.
13/4/2015. 1000. Yes.
34.
Also date will come.
Mine.
This is a Belgium matter.
Yes.
NBW was issued on 15/5/2023.
35. Item 35.
34.
15/5/2023.
15/5. Okay. Bail
Bail ମାନେ 21/11/2018.
18. चलो 500.
35.
Yes.
May I please, Your Lordship?
Yes.
It's a Belgium matter, my lord. NBW was issued on 28/2/2024, my lord.
Bail
My lord, it is a complaint case, my lord, where cognizance was taken and NBW was.
the present case is arising out of a complaint case. The petitioner was on bail. However, due to default in appearance before the court on 28/2/2024, NBW has been issued. Suffer same order. 500, huh?
36.
Please, my lord.
Yes.
My prayer to quash the NBW issued on 23/2/2013 in Mona PS case number 33 of 2012.
You were on bail?
No, I was not on bail. My name neither appear in the FIR, nor my name was also stated by any of the accused. Nothing.
But charge sheeted?
Yes.
Absconding and all.
Yes, charge sheeted for without any allegation against me.
Whatever, I am not considering those things. Okay. The petitioner.
Allow me to surrender.
Petitioner, the charge.
Anticipatory bail file
I know.
certificate is there now.
The petitioner has been charge sheeted for offense under section 20
B2C.
Roman 2 bracket C and oblique 29 of NDPS Act, showing him as an absconder. Therefore, the NBW has been issued against him by the court below, by the special judge cum sessions judge Barola. Paralakimundi on 23/2/2020. 2020. He assails the same. Subject to petitioner appearing before the court on or before 30th of May so and so, and paying a cost of rupees 1,000 to be negotiated to so and so. The NBW issued by the so and so court on 23/2/2013. The operation of NBW, execution of NBW so and so is remain stay till 30th.
37.
My lord, Benjo matter, my lord.
Yes.
My lord, Benjo matter, my lord. NBW issued on 7/4/2023, my lord. Petition number 1 revision bail on 14/10/20 and petition number 2 on 23/3/2021.
NBW 7/4/2023. 500 each.
That's it.
Yes.
Bless me.
38.
NBW issued dated 30/8/2022. KBL bill 485.
Absconder. Petitioner is
No, my lord,
accused.
he is in village now. He's a laborer. No.
Whatever, you were absconding one way. Petitioner, charge sheet was filed against the petitioner, showing him as an absconder. Therefore, NBW. Therefore, subsequently, NBW has been issued by the court of JMFC Hadavanga on 3/8/2022. In city case number.
PS case number.
Hadavanga
PS case
number
109 of 2020.
109 of 2020. Yeah. Subject to petition appearing also, paying cost of how many? 500. Take it.
39.
39 also say NBW.
Same.
24/6/2013.
Same absconder. তারপরে 24/6/2013 রে NBW ହେଇଛି তারপরে এইটা হচ্ছে ইউরোপে 1000 yes 40
My lord, Belgium, my lord.
Not Belgium, convicted.
Convicted, my lord. On the 166 case, convicted.
এটা captain আবার
ସବୁ captain ଯୋଉଠି absconder captain all absconder captain
all absconder captain members.
और बाकी एगुड़ा citizen ठीक है हाँ 40
Lord, sir, petitioner convicted on 21/11/23 in the 166 case, my lord. And NBW issued on 18/12/2023, my lord.
I convicted on
138 of NA Act.
138 NA Act petitioner was convicted by judgment dated 1/7/2023. You have to go and file appeal and
Yes, my lord. NBW.
Direction page से direction page appeal page
you cancel कर भी
Lord, sir, NBW may be request, I will file appeal within.
right on under section 138 NI Act.
Yes.
And NI Act because he was he remained absent. NBW was issued by the trial court on
18/12/2023.
18/12/2023. Land counsel or the petitioner submits that he would be preferring appeal against the conviction and sentence passed against him on or before 30th of April. So, subject to preferring an appeal, the appeal by the petitioner, the NBW issued on certain said there is the operation of execution of NBW so kept in away. I'm keeping it away. Go and file appeal and get
time limit of control section 12.
30 में भीतर करिए
Within 30.
हाँ within 30th रे appeal file करो move appropriate application it will not be executed ठीक है okay 41
May I please, my lord?
yes
Case of Belgium.
yes
NBW issue on 28/2/23.
12/9/2023 NBW where you are in bail.
Yes, sir.
Tell me the date.
BLFL number 5594/21.
Tell me the date, sir. Date. देखो
Warrant date
21/6/2022
Sir.
You are on bail. 21/6/2022 on bail. NBW is on 12/9/2023
What is be written?
नहीं थी BLPL लिखी ना BLPL ठीक है 500 42
My lord, order dated 25/9/2007, Annexure 1, your lordship, NBW issued. Your lordship, he was on bail. And by order dated bail date ହେଲା BA number 154/2005 and 24/3/2005. 24/3 by furnishing bonds and released. Your lordship, the cognizance has taken and someone
1,000
huh?
say 1,000
Anything.
it is NBW cancel 1,000
NBW recall ହେଇଯିବ ଆଚ୍ଛା ଏଇଟା 25/9/2007 SDGM ପୁରୀ now it is fixed in JMFC କୋଣାର୍କ ଟ୍ରାନ୍ସଫର ହେଇଯାଇଛି ସେଠି ନୂଆ କୋର୍ଟ ଗୋଟେ ହେଲା ତ କୋଣାର୍କରେ 4/5/2022 ରେ ଟ୍ରାନ୍ସଫର ହେଇକି ଆସିଛି କାହିଁକି ମୁଁ କଣ କରିବି ସେଠି ତ କେସ୍ ପଡିବ ଟ୍ରାନ୍ସଫର ହେଇକି ପଇସା ଦେଉଛି ଖାଲି ଆଜ୍ଞା
1,000
ହଁ JMFC କୋଣାର୍କ ପାଖରେ କୋଣାର୍କ ଡିଷ୍ଟ୍ରିକ୍ଟ ପୁରୀ ନୂଆ କୋର୍ଟ ହେଇ ତ ସେଠି ସେ ପଢେଇ ଦେଇଛନ୍ତି
May please, Your Lordship. Your Lordship, the date of bail is 23/11/1998, Your Lordship.
98 huh?
Yes, Your Lordship.
Okay.
And the date of issuance of NBW is 15/3/2003.
How many of you are there? Pay 1,000
Your Lordship, pending in the court of JMFC Talcher, Your Lordship.
you have written rightly
Your Lordship.
in the body you have written right
Yes, yes, Your Lordship.
we'll
Much
check it we'll check
yes, Your Lordship. Much obliged, Your Lordship.
44
May I please?
Yes.
Case of Belgium. NBW issued on date 14/3/2023. Relevant page is page 22.
You tell me the bail order.
Bail order and para 4, I have taken a specific averment that is on page 3.
Tell the date.
BLAPL number 2046 of 2020, and he was released on bail on 12/2/2020
12/2/2020.
by this honorable court.
14/3/23. Okay. 23, 500.
Oblast.
45.
बेलजियम मैटर मेलर 4/3/21 बेल हेतला बेलजियम हेची 13/9/2022
4/3/21.
मेलर
4/3/21.
मेलर
Bail 4/3/21.
बेलजियम को 13/9/22
13/9/22. 21 लिखो यार. Okay, 13/9/22. इंडेक्स रे 21 13/9/22. ठीक है. 500.
ओब्लाइज मेलर
46.
Belgium matter, your lordship, NBW was issued on 22nd November 22/11/2023. He was in bail 11/5/2015.
500.
47.
This is Belgium matter, my lord. NBW was issued on 18th April 2016, my lord. It was bail on 27/7/2009, my lord. 9/09.
500. 1,000. 1,000. Yes.
48.
May I please, Lordship? Lordship, I was forwarded and charged under section 420, Your Lordship. Custody since 23/12/2023, Your Lordship.
Yes. 48, 49, 50, and 51, my lord. And one of the co-accused
is released on bail, Your Lordship.
Let's see. In BLAPL number.
You are in custody since?
My lord?
Custody since?
Custody since 23/12/23.
23/12/20.
My lord.
I'm giving the one website and other, my lord, the materials, my lord. And see paragraph 5, my lord. The IO given the instruction, my lord. Paragraph 5. He actually was granted, well, he is the mastermind, man, he created some documents, man, and these petitions helped him in different manner. And
Prosenjit Das was working as a
granted bail, man,
provides home loan.
man.
He is Rajesh Kumar,
No,
Abdul Rahman, Prosenjit Das. Prosenjit Das.
And another case. Prosenjit
Biju Tripathi.
2605 Prosenjit. BLAPL number.
Yes. Para 5 you are reading, yeah?
My lord.
During the course of it is ascertained that the accused Prasanna Kumar Das was working as a direct sale agent to provide home loan, personal loan, insurance, credit card, so and so, was also assisted Prasanna Das in this regard. He, Prasanjit Das.
Ankita Sahu.
He had kept all the information about the
credit customers. Earlier to this, Ankita was working as SBI.
Was working as SBI credit card sector. Both the accused persons were dedicated the original credentials of the credit card customers and applied for new credit cards. Ankita is also accused.
Accused, my lord. She has been granted bail 41, my lord.
They are seeking parity with that Ankita only.
No, my lord. They are, my lord, parity, my lord, the Pradeep Kumar Samantray.
Okay, let us see.
Projects lateral, my lord.
Fill up the application sent by Ankita Sahu to Pradeep
Samantray.
Pradeep.
And who has been granted bail by your order?
Verification through the live photo and contact number and approval. But Pradeep Kumar was first.
Who is the bank employee, my lord?
The immediate superior Gollavi Madan, and without her consent and knowledge, and with the final approval of the authority of her credit card. After activation of the credit card, Prasanjit Das was came in contact with one Mukesh Mantri and were working in a real estate working as an agent, and he was suggested name of
BJP Party, another co-appeal, my lord.
BJP Party, I am for BJP Party.
Each amount of transaction made from the credit card through hospital billing counter. In this scandal, accused Abdul Rahman, accused Rajesh.
Abdul Rahman, another accused. And BJP will also there, my lord.
The whole trustee united the family. They gave a single seat article, which mobile phone
And it's paragraph 6 materials were recovered from the Prasanjit and Bijuti Bhatt. Yeah, created the credit card and utilization first. Utilization asset submitted.
And what about the final charge sheet? How much time?
Pardon?
How much time will it take?
Final charge sheet has not been submitted, my lord, because some of the co-accused persons are the land, my lord, they have not applied.
Who are
Ankita, my lord, religion bail.
insofar as these accused persons are concerned, charge sheet is filed.
That's from them.
Complete charge sheet is filed.
And the order of the my lord, Pradeep.
What is the amount involved in total?
My lord, total amount involved, my lord.
1 lakh. 1 lakh. 1,40,000 was alleged. Your Lord.
One person super the petition is concerned, my lord.
What about the how many people?
Total, my lord, cash 7,870. That
The
is recovered
will
from
not
the-
do investigation is going on. They might have.
That is, my lord, recovered from the possession of Prasanjit Das and Bijuti Bhatt. Both are they are there.
Prasanjit Das and
Prasanjit Das, both the accused persons, my lord. That is recovered. And both of they are Prasanjit and Biju also bail options here, my lord.
So who is the main accused? That Prasanjit.
Prasanjit, my lord, creator of this is. He contact with the Ankita, and Ankita was working the SBI credit card, my lord, the earlier, my lord. He
Abdul Rahman and
Abdul
Rajesh
Rahman.
Mardas.
there, my lord, they utilize the card, my lord, in medical and other booths,
So
my lord.
they are
Obtained the money and taken the share, my lord.
they are entitled for bail immediately.
My lord.
Will
All the role is police has done or the court has done. You have not
Hon'Ble,
done.
I am
You have manipulated
manufacture-
credit card. Just see the scam. Manipulated credit card and you say you don't have any role.
when persons are needed in money, they give credit card to Biju. Biju showing it.
Biju giving it to Prasanjit,
No,
clown it and created.
Prasanjit and Ankita, what my learned friend told. Prasanjit,
In fact, but he is in fact the main accused.
My lord. And Ankita created the credit cards, my lord. And Prasanjit, my lord, for the signature of one Pallavi.
Accused Ankita 41 notice was given. One of the co-accused has already.
Pradeep Kumar Samala. Pradeep,
One Pradeep Kumar Samant, right?
Pradeep Ankita, Pradeep Ankita.
Injection order, my lord. Instruction last page, my lord. Injection order, my lord. Instruction. Last page.
420-34.
Give me the order, my lord, the Pradeep.
Give it. Right on. All the five, na?
All the but total 5 is here 4, my lord.
4, 8, 4, 4, same day.
23/12/2023.
Charge sheet qua the petitioner has already been filed by the police on
Sir, dated 19/2/24.
19 to
24. With a charge sheet number 7.
the indication against this is the petitioner has the police has filed a charge sheet stating that this is a scam and the petitioner is the party to the entire scam. The preliminary charge sheet reveals that para 5. Para 5, para 5, and para 6. Para 5 and 6. Para 5,
6, 7 there.
7 days. Prima facie likhti.
5, 6.
There are the co-accused persons are absconding. Therefore, the prosecution has kept the further investigation open under section 173(8) KRP. Then counsel for the petitioner submits that insofar as the co-accused Ankita's house is concerned, C was enlarged on bail. C, the police issued notice under section 41C, and she was admitted to bail. So she was admitted to bail subsequently. One of the co-accused persons, namely Pradeep Kumar Sahu, has also been enlarged on bail by this court by its order dated 1/3/2024, while allowing the BLAPL application, BLAPL number 586 of 2026. So the petitioners are seeking parity with these accused persons. The role of the petitioners in the scan are more or less the same. Two co-accused persons have already been granted. Preliminary charge sheet has already been filed. Insofar as the absconding accused persons are concerned, further investigation is kept up. Therefore, Mr. Ragala submits that this is a scam involving about 7 lakh rupees. 7 lakh rupees, and insofar as the present accused persons are concerned, the investigation for them has already been completed.
On 7,07,870 recovered from the Biju and the Prasanjit.
About 7 lakh. Okay. And no more custody is required to the present petitioner. Take into consideration. However, he submits that since it's a big scam and further investigation is kept open, their cooperation during the investigation, further investigation, is essential. Accordingly, stringent conditions should be imposed. Grant bail with the condition to be quick and proper with the further conditions that the petitioner 123%. The petitioner appear before the IIT and appear before the IO of the case. IO of the case as when required. Agent when required during the further investigation of those.
And they also not commit similar type of offenses.
Next, during also, we shall not commit similar kind of offense. Third, the accused appear before the IAC, which
cyber crime and economic offense case.
Cyber crime, economic offense.
Cyber crime and economic offense case.
थाना नहीं से
थाना नहीं, that's खाली से
cyber crime and economic offense. Yes.
The PS name is cyber and economic offense.
बहुत थाना अच्छा, बहुत थाना अंडर कोटेड कर देती cyber crime.
वो थाना कौन
भुवनेश्वर, मैंने कहा भुवनेश्वर. In connection with the which police? Cyber crime and economic offense SBS.
Bhubaneswar.
प्रति थाना रे कोटेड कर देती है.
Bhubaneswar every Sunday for a period of till the further investigation is completed, and final charge sheet under 173 is filed by the investigation.
50 case number.
Cyber crime case.
Violation of any condition, aforementioned any condition, will entail cancellation of bail.
Obligement.
Yes.
52.
Yes.
Dear my lord, the petitioner is convicted under section 395 of IPC, my lord, by the learned assistant session judge Baliguda, my lord. And thereafter, an appeal has been filed by the petitioner. And in that appeal, he has filed a petition under section 389 CRP similar for
Sentence.
7 years, Miller. And I have filed a copy of the judgment that was Miller. That bail petition was rejected, and that's why I moved. 7 ବର୍ଷ ସେ ରହିଲାଣି 26/6/2023 ସେ last 10 months.
କେତେ ଦିନ ରହିଲାଣି?
Custody since 26/6/2023.
10 months.
10 months. Miller.
Appeal is admitted.
Appeal admitted.
Where is that?
Appeal Miller, that is at appeal number is at page, your lordship may kindly turn to page 10.
23.
Page 10.
Right. Petitioner was convicted. Petitioner has been convicted for offense under section 395 IPC. IPC, and awarded a sentence of substantive sentence of 7 years arrived.
And
fine 25.
By the court of assistant sessions at Baliguda in ST case number 92 of 2023. 23. He has preferred an appeal. Where is that?
And that is at page 10. Criminal appeal number 8 of 2000.
He has preferred an appeal, being criminal appeal number 8 of 2023 before the Court of Additional District and Sessions at Baliguda, which has already been admitted. He moved an application under section 389 CRP for suspension of sentence during pendency of appeal, which has been rejected. Therefore, he seeks indulgence of this court. Let counsel for the petitioner submit that the petitioner has been taken into custody after the conviction. During trial, he was on bail.
Not on bail. 26/6/2023, trial was not on bail during trial.
He was not bail.
He was on bail.
No, not bail.
After conviction.
So sanction trial ସରିଗଲା.
During course of trial and
2023 ରେ arrest ହେଲା.
କେବେ trial ହେଲା ଏତେ ଜଲ୍ଦି?
9/11 arrest ହେଲା 26/6/2023 ରେ, ନଭେମ୍ବର ମାସରେ trial ସରିଗଲା 9/11/2023.
Very lucky that.
case.
Custody on 26/6/2023. 6/2023. 23. The trial of the case is concluded on 9/11/2023. 2020. Therefore, he has undergone about how much?
7 years. No, I have undergone 10 months.
About 10 months.
Till 2 days.
About 10 months. 10 months. Taking into consideration the period of custody and the fact that the appeal is repeated by the court below, I am of the considered view that the petitioner is entitled for grant of bail. Grant of bail. Accordingly, the sentence. Where is the sentence order?
Order Miller, judgment copy I have filed.
Sentence order.
Yes, Miller. At page 14. Page 14. Separate judgment I have filed, Miller, copy.
Page 14.
Page 14.
Hearing question of sentence.
14 ଛାଡ଼ିକି ବାକି ସବୁ ଅଛି ମୋ ପାଖରେ।
ନାଇଁ ଜଜମେଣ୍ଟ କପିର 14ଟା ଗୋଟେ ଦେଇଛି। ଜଜମେଣ୍ଟ ଗୋଟେ ଜଜମେଣ୍ଟ କପି।
Sentence order must be a different order.
Manner.
Separate hearing.
Hearing on the question of sentence.
Where is that sentence? Give me that is not there.
ନାଇଁ ଦେଇଛି ସେଟା ଜଜମେଣ୍ଟ କପି।
89 more. Sentence order. The order of sentence passed by the additional sessions judge Baliguda by on same day, na?
Yes, on same day.
Same day. Date day, na?
9/11/2023.
9/11/2023. Shall remain suspended during the pendency of trial.
Yes.
Yes.
Fine also.
Hand the city devel.
Fine ଟା stay.
Function code devel. City I devel. Hand the city.
ନା ଦିଆ ହେଇଛି ଦିଟାଙ୍କ ରିଜେକ୍ଟ କରିଛନ୍ତି ହଁ
Condition to be imposed by the appellate court. Right. Next. 53.
May it please my lord, my lord, I'm appearing online, my lord, with your lordship's kind permission, if I may, my lord.
Yes, yes.
I'm grateful. My lord, this is a matter, my lord, where your lordship will kindly see, Prevention of Corruption Act, my lord, I was roped in as a private individual, granted bail eventually. My lord, the trial today is underway. Page 28, my lord, if your lordship kindly see, is a bail condition. There is a bail condition when I was granted bail on the 6th of...
Where is the bail order?
Bail order, my lord, your lordship, it starts at page 21, annexure 2, which is dated 6th of September 2022. Your lordship has the bail order, my lord, page 21.
21. Yes, which
I'm
condition?
requesting your lordship to turn to page 28. That's the operative part of the order that I need to, my lord, show your lordship.
20. Yes.
My lord,
Which
the
condition
accused
you are
petitioner, the first one, the accused petitioner shall surrender his passport before this court at the time of acceptance of bail bond. So, my lord, I requested the sessions court, the trial, which is the trial court in my case, my lord, for a modification of this. A reason being, my lord, I'm a director with OSL Stevedores, which is one of India's largest stevedore companies. I am also, my lord, a director in OSL Motors, which is again, my lord, has a very large network of motor showrooms for BMW, for Toyota, etc. in Orissa, in West Bengal, etc. So, my lord, I need to travel abroad frequently because, my lord, as your lordships are aware, for these business promotions, etc., my lord, and negotiations, I need to travel abroad all the time. So, I requested the trial court, since the trial was taking some time, for, my lord, a modification of the order. Your lordship may kindly turn to the impugned order, where this modification application has been rejected, which is why, my lord, I am before your lordships. Page 66, yes. Your lordship kindly sees, is the impugned order. This order arises out of an application filed by the accused church. Page 66. That's the impugned order. This order arises out of an application filed by the accused Churchit Mishra, seeking a prayer for modification, the condition number 1 of the bail condition, to allow the petitioner to get back his passport. Now, my lord, the learned court narrates some of the facts, and that page 68 is the operative part of the order, my lord. And that makes very interesting reading, my lord. Peruse. Your lordship have the second para, peruse?
Yes. Peruse
the case record
and other materials.
I'm grateful. And other materials available on record. In the present case, accused petitioner is charge sheeted under 120B, read with all these sections of the PC Act. The record reveals the accused was released on bail on 6/9/22, and this court imposed 3 conditions, including one of the conditions that the accused petitioner surrender his passport before this court at the time of acceptance of bail bond. There is no material to hold, if my lord would just kindly mark that if it's possible. There is no material to hold that the accused petitioner has violated any terms and conditions imposed in the bail order of 6/9/22. Accused petitioner has filed his petition to modify the condition number 1 on the ground that he is one of the directors of OSL, which is a registered public limited company, and carrying on multi-purpose business work, including ports inside India and abroad for the purpose of promoting business. Unless the condition is modified, the passport of the accused petitioner retained by this court cannot be returned in favor of the accused petitioner. In a decision of the Honorable High Court, my lord, in that case, in the case of Mithu Burma, this Honorable Court was pleased to observe. Before proceeding further, I feel that a glaring mistake committed by the learned trial court below needs correction. By the order dated so-and-so, the trial court, the additional session judge reduced the cash security to ₹10,000. As per the provisions of section 439(1)(b) of the CRPC, any condition imposed by a magistrate when releasing any person on bail can be set aside or modified by a court of sessions or the High Court. The power is not available to the court of sessions to modify its own order. It can be so done only by the High Court. On this point, reference may be had.
Yes,
so
who is
this
appearing?
point on law, my lord, this point,
CB.
Then I have to issue notice.
But I'll just take, would your lordship, yes, Lord, I think notice is the best thing. Lord.
Yeah,
Only thing,
see,
Lord, if your lordship.
what can be done is, as and when you will leave the for overseas,
I'll tell you, Lordship.
Then you seek permission from the court. I'll modify to that
Now,
extent.
may I, just 1 minute, Lord. I just need 1 minute from your lordship. Firstly, my lord, the passport to be returned to me is a fundamental right, my lord. That if your lordship like, my lord.
That's what I'm saying. That's what I'm saying. The passport will not be retained by the court. As and when you leave the country, you seek permission. As simple as that.
My only
prayer before the court. Whenever you
We'll
go
allow that.
outside, you seek permission and intimating where you will visit.
Whenever you leave the country, you seek permission. As simple
Your
as that.
lordship may direct to hand over the passport. And whenever the petition will go abroad, you will seek permission from the court.
That will suffice.
Yes, Lord, if I may, Lord, there is also a slight tinkering with this order which is possible. Your lordship may consider, and in your lordship's wisdom. Just if my lord, Mr. Acharya, who is in court, if he can hand over to your lordship, my lord, a matter where I had appeared in the Delhi High Court, Suresh Nanda versus Central Bureau.
I understand it, but I can't pass the order ex parte.
I follow. I'm only, my lord, so that they can take instructions if need be, but this is something, my lord, instructive. So your lordship may just have a look at it, my lord. This is an application, it will take 2 minutes, my lord. I won't take more than 2 minutes.
Yes.
This is an application praying for modification of an earlier order dated 11/5/21 passed by the court in present criminal appeal, by which the sentence was suspended on the following: the appellant shall not indulge in any illegal activities, my lord, without, and he should not leave India without.
Exactly the similar order I have passed in many cases.
Now, your lordship may just bear with me for a minute. That's all.
Right.
My lord, the learned counsel for the applicant is, and this is, my lord, a case after conviction. He was already convicted. This was, my lord, at the appeal stage before the High Court. Now, your lordship may just see, my lord, paragraph 4, my lord. I have heard both the counsels, the previous conduct of not violating the conditions of any point, and the fact that he has to travel abroad to take care of his medical and business needs, and the fact that an FDR of 10 lakhs is lying. The condition imposed earlier are modified as under, relying on the decision of a coordinate bench of this court in G. Vetrivel Sami. Will kindly see this. The petitioner shall not leave the country without informing the trial court and IO a week in advance of his visiting abroad, shall furnish complete itinerary stating the countries which he intends to visit and the period of his stay, as also the addresses where he would be staying and his contact numbers. He shall also inform the trial court and IO in writing about his return to India within a week of arrival. The applicant shall share his mobile number with the IO, which he will be carrying during his travel abroad, and keep the location app on at all times.
We will incorporate this condition and alter the earlier condition. As simple as that. Issue notice.
Perfect. Because I'm so grateful. Lord. I'm so grateful to you.
We will incorporate these two conditions, and that condition we will alter.
My lord,
substitute this.
Copy was served on the CBI.
I'm so grateful, Lord.
We'll keep it Monday. 50. Where is that? Monday is
would your lordship consider?
29. 30th.
Milord, would your lordship kindly, Milord, consider if it's possible, if it's convenient for the court to have it, Milord, on 30th, Milord, if it's possible, Milord. On the 30th, or would it be possible?
30th.
Instead of 29th, 30th, Milord.
30th, okay. 30th, please.
Is your lordship holding court on 30th, Milord? I hope your lordship is not sitting in some other bench, Milord, in a division bench or something.
Sorry.
Is your lordship holding court on 30th, Milord?
Yes, of course.
Because your lordship sits on the division bench side also very often.
No, I'm holding.
I'm grateful. I'm very grateful.
30th, issue notice on 30th.
Grateful, Milord. Deeply grateful.
Yes. 5 minutes. 5 minutes.
54. May I please be for a lawsuit?
15. 54.
My lord.
5 minutes is there.
My lord, this is a quashing of proceeding on the ground of my lord.
Before lunch, if you finish little more,
yes, my lord.
After lunch, there is less pressure.
Small matter, my lord. In view of the compromise decree of the divorce proceeding, 498 quashing, my lord.
Where is he? Call her.
My lord, already they have stated your lordship turn to page.
They have to come. They will come.
Your lordship have only 51. They have joint affidavit. They have also 51.
That's right, sir. I am accepting it. Bring them today also at 2 o'clock. You bring and
No, my lord, she is serving in IT
Online.
sector.
online. We see.
Yes,
Tomorrow
tomorrow, your lordship keep it. Next week, I will intimate, my lord.
you bring anytime. Anytime. Right.
Fix a date, my lord.
I'll issue notice. Shall I issue notice also? No, you bring it. Notice means again it will take unnecessary time.
Yes, your lordship keep it on 30th.
30th, okay. 30th. Settlement matter 30th. Huh?
55.
May begins. There was last occasion the order dated the 7/12/2023 mallership that this honorable court stay the further proceeding of the non-trial court and directed me to issue
They have not remember they filed the completely requisites, madam.
That's why the matter was still pending mallership.
See, you have taken the stay order on 7/12/2020.
No, mallership, I'm filing the petition copy, but not the annexures. That's why the
Whatever, after taking stay order, you can't do.
I'm already
2 years, more than 2 years.
But this matter is as per my information.
Whenever notices are issued, you say no court.
No, mallership.
Always reluctant to.
Also, this matter already, as per information taken by the trial court, that matter was amicably settled between the parties, and both the parties.
What is the report? What is the report?
It is my information that I collect from the Lord Advocate from the trial court.
Requisite file? Huh? When he is filed?
The requisite not complete requisite.
Complete.
For that reason, the notice could not be issued.
I'll impose cost. Otherwise, vacate take.
Mallership,
You take either of this.
Mallership, kindly fix the matter in a short day.
No, not short date. You talk about vacation of this day. I can't tolerate this. That is the reason I'm not giving stay.
Mallership, I'm filing the document.
Why have you not filed? That's the question. How much you will pay to the bar?
He is a poor person.
Poor means then why are you taking the stay? Then I will vacate the stay.
That is my fault. That is not in the idea that complete document.
You have to pay. You have to pay some cost to the bar.
Mallership, he is a poor person. That mallership, as per convenience, mallership
on
500 mallership.
7/12/2022. This court had issued notice to opposite party number 2 and grant interim stay of the proceeding before the court below. Interim stayed the proceeding in GR case number 36 of 2019. Due to incomplete requisites being filed by the petitioner, notice could not be issued. The stay order is operating since last about 2 years. The petitioner has not taken appropriate steps to ensure service on the opposite party. When the matter is taken up today, let counsel for the petitioner seeks further time for filing the appropriate requisite. By way of last opportunity, 1 week time is granted to the petitioner to file appropriate requisite, subject to condition that petitioner shall pay cost of rupees 1,000 to be deposited with the High Court bar. And release the matter first week. And it is made clear that if the sufficient requisite is not filed, the entire petition will be dismissed without reference to the court. Without reference to court, automatically it will be dismissed. Yes. Within 1 week, if you don't file.
By tomorrow.
Within 1 week also, you have to pay 1,000. Then
this is my fault. That due to lack of knowledge, I am just filing the petition copy.
While taking stay, you had all knowledge.
This is my fault.
You pay to the bar only.
Yes, my lordship. But kindly fix a date.
Date is fixed. 3rd May. Within 1 week, you file it.
Yes, by tomorrow, I file the.
Item number. Please pay 1,000 today.
I am ready to pay because it is my fault.
We are giving to your brother.
That is the bar to the left.
May please, Lordship.
Yes.
Here, my lord, the application of the present petitioner under file under section 457 for release of the vehicle has been rejected under annexure 3 by order dated 5/3/2024. The petitioner is the owner of the vehicle, and the allegation is that, my lord, on 21/11/23, the excise Boinda, while performing patrolling duty, they stopped the vehicle. The vehicle did not stop, and being followed the vehicle was detained and found 140 kg of
You
ganja.
are the accused,
No, I'm not the accused. I'm the owner.
owner of the vehicle.
Owner of the vehicle.
You are not the accused.
No, my lord. The
What is the reasoning?
reasoning, my lord. Lordship, kindly give a glance to page 23. Applying section 52AI, he is rejected. There was no confiscation proceeding against the vehicle. Lordship, page 23, last person. On bare reading of section 52A1, it is clearly stated that the central government may, having regard to the hazardous nature, vulnerability to theft, substitution,
Yes,
constraint.
there was a judgment recently. I have also passed on it. Where I have said that 52A will not bar.
Yes.
But in spite of repeated invitation to the owner, that they did not go for which the conspicuous proceeding process could not able to done. For which that has been.
Confiscation has already been made. Done.
No. Confiscation where? Where it has been mentioned?
Confiscation proceeding is going on.
No, my lord, no. No. Page 20, my lord. The court will observe that in this case, supported document of the vehicle has been filed with the petition on bare reading of the registration certificate of the vehicle. It is seen that the present petitioner is the owner of the vehicle. He has also filed his Aadhaar card and smart card of the vehicle along with a copy of the insurance to show that she is the owner of the vehicle. Heard from both the sides, and the advocate for the petitioner forcefully submitted that present petitioner is the owner of the vehicle and she is not accused in the present case, and hence the petition under section 457.
Where have you read that part where confiscation proceeding is on? Yes, Mr. Rao.
Yeah, my lord.
Where from you got that?
My lord, senior perhaps referring that para 5 of that order, where the session, while rejecting the application, the court will observe that under section 63 of the NDPS Act, it is clearly written that any animal or conveyance used in carrying any narcotic drug or
liable to be confiscated.
Liable to be confiscated.
Yes, my lord. I may pardon. Yes, my lord.
But whether confiscation
No,
proceeding has
my
been
lord, no.
initiated or not?
No, yes,
No, my lord.
I'm sorry, my lord.
Get instruction then. I'm just issuing notice, just instruction. And cut out of that judgment which I have passed.
My lord.
I say that there is no bar.
My lord.
I passed the judgment. Huh? Just check it up. Huh? Check it up.
Yes, my lord.
Speak to him. Check it
Let's
up.
keep it to
Give it. Second week. Second week. May.
Well, vehicle is returned, my lord.
So therefore second week.
Lordship, first week of May.
First week, even if I lease, it may not reach unnecessary why. ठीक है?
Date. Huh?
Next. Yes, next.
Judgment at
56. But just see that judgment, huh?
My lord.
56.
Yes, my lord.
My lord. My lord, on behalf of Hon'Ble Ratna Pandit, my lord. On behalf of Hon'Ble Ratna Pandit, may be permitted, my lord.
Yes.
My lord, case of offense 52A of Odisha Excise Act, my lord. In this case, I pray for surrender first or second or on same day, my lord.
This is you are asking for quashing of the entire proceeding.
My lord.
What is the stage?
Stage, my lord, charge sheet submitted, my lord.
Charge sheet, you have not filed anything except a copy.
Only I pray
except
for-
FIR.
My lord. I pray for only surrender first or second.
You surrender. Then counsel for the petitioner seeks to withdraw this petition in order to surrender before the court below and avail remedy under law with this liberty. the petition is disposed of. Yes. Next.
May I please your lordship. Here, my lord, the petitioner lodged an FIR against the accused person for the offense under section 498A, 304B, 306, 406, and 34 IPC along with 4 DP Act, my lord.
What is this order?
My lord, this order, my lord, after the filing of the charge sheet, my lord, and the Law and Trial Court taking cognizance, the petitioner filed an application to direct the IO to seize the
everything is all right, but in the petition, except the order, one order, what is that? Order dated 6/9/2022. You have not filed a single document. And I have to decide the criminal case on the basis of whatever oral statement you are making. Shall I record your statement on oath?
No.
Then only I can rely upon that. These are criminal cases. You don't file any document. One page order you are filing and asking to quash everything.
No, I am not quashing, my lord, everything, my lord. My humble submission before your lordship that I have filed an application before the trial court.
Where is that application?
My lord, that application I have not filed. Sorry, my lord, sorry.
You have not filed anything?
Regarding this,
starting from charge sheet, everything you are arguing. Under no file, let counsel for the petitioner. I'll at least complete petition so that one can read and understand what you are saying. At least, it is expected from you at least.
Sorry, my lord.
You have experience. Why can't you do that?
My lord, sorry.
Let counsel for the petitioner seeks an adjournment to file additional document to substantiate his case, leaves the matter. Meanwhile, you file. Whatever document you want to file, file by way of petitioner.
Oh, bless me.
58.
Withdraw.
59. May I please, lordship? My lord, petitioner challenging the order of cognizance, which is under Annexure 1 at page 16, my lord.
What is wrong in it?
My lord, this cognizance order is arising out of the one private complaint. May I read the order of cognizance, my lord?
No.
My lord, this cognizance order is bad in the eye of law due to 2 reasons, my lord. Because, my lord, the code below has not been fulfilled the provision of 204 of CRPC while taking cognizance. My lord, section 204 CRPC, subclause 2, my lord. 204 CRPC subclause 2.
Yes, tell me.
No summons or warrant shall be issued against the accused under subsection 1 until a list of the prosecution witnesses has been filed. Here in this case, no witnesses has been filed from the side of the complainant. This is the fact.
It is arising out of which case?
My lord?
It is arising out of a complaint case.
Yes, my lord.
He might have examined the witnesses.
Yes, my lord. But second thing is, my lord, the code below has taken cognizance upon the section 380 complainant against the para 8.2, subpara 8.2. Under Annexure 4, my lord.
What is this? This is?
My lord, this is the allegation against the petitioner by the complainant.
This is the complaint.
Yes, my lord. Annexure through Facebook and subsequently developed her friendship with the complainant. Then the complainant was residing at his own house at CDA. That after some days, the accused number 1 started to come closer to the complainant and gradually developed relationship between both of them developed. The complainant was completely unaware of the ill intention of the accused number 1, that the accused started extracting money from the complainant in various ways. Being an innocent guy, the complainant arrayed and trapped by the accused number 1. That the accused number 1, who is elder than the complainant, trapped the complainant to get married her and somehow managed to make the complainant agree. After some days, she started
claiming regarding various internal issues of the complainant's family and started various disputes.
So what do you want? What is your?
My lord, the ingredients of 384 has not been
That's
traced out.
you argue at the stage of charge, framing of charge.
But my lord,
Ingredients are there or not? All
yes,
these
yes,
things
yes,
will
my
be
lord. But
examined. What are the other evidences? Where are the statements? 200 statements. It is made out.
no, my lord.
You
My
may
lord,
say no, but it is made out according to.
no, my lord. As per section 384 of IPC, the ingredients. What is the ingredients
See,
of
that is a different state.
my lord?
I'm not going to see one section after another.
Yes, my lord. But my lord, Honorable Apex Court observed in GLC Employee Stock Option Trust versus India Info Limited case that in para 14, my lord, in para 14 of the judgment, my lord, page 7, my lord.
Yes.
Be that as it may I read, my lord? Be that as it may, as held by this court, summoning of accused in a criminal case is a serious matter. Hence, criminal law cannot be set in motion as a matter of course. The order of magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. My lord, here with this complaint, my lord, not a single document has been annexed by the complainant, and also he has stated that I have approached to the police in regards to the complaint, but not a single written documents has been annexed with the complaint. Therefore, without applying the judicial mind, the magistrate has passed the taken the cognizance.
Another surveillance was filed earlier.
So that is for
2931,
205. That is for 205 appearance rejected by the lower court.
What?
This is a factually, it's a scam. So it's a big scam and that is individual cases. So the 200 statements. We need 200 statements.
So the 200 statement is completely different from the complaint petition. And here, my lord, the complainant is suppressing the material fact before the lower court, my lord, while filing this 1cc.
See, the allegations are serious allegations.
My lord, this allegation is serious, but without any
will be tested in the trial. 200 statements are very clear to raise all the points before the to maybe correct also.
60, my learned senior Mr. Vishnu Prasad Pradhan is on his legs. So kindly
urgent.
Lead it matter.
61.
Might be this, as if defect is there, certified copy has not been filed, I may be permitted to file it.
Time to secure the defects. Yes. 60.
62.
61 to 63 are all from arising out of same FIR.
And 63 also.
61, 62, 63.
63 also.
My lord, on your lordship's direction, both the parties have appeared and they are filing affidavit even. There are 3 cases. My learned senior is appearing in 2 cases and I am in the first case.
This is for quashing.
Yes.
Where are the parties?
My lord.
Just check it up. Mr. Rahul, Maharaj, Mr. Maharaj is there.
Maharaj.
Mr. Ragada is there. You can check it up. Check it. This is only one item, na?
Yeah, no, there are three items, my lord. Yes, connected.
Madam, they have filed FIR against me.
And
Since the police has filed final report for rest of the accused persons, they have filed a complaint case.
a case and complaint.
And that complaint case, cognizance was taken. Therefore, there are two cases filed by me. One is against the cognizance taken in complaint case, lost by.
Which one is the first case?
My lord, first case is my lord, is mine, my lords.
What is that?
TRLMC 5000.
1935.
Suchit Sahu.
Suchit Sahu.
Court officer बोलूँ Smita Sahu, Sanjukta Sahu, Manoj Kumar Sahu, and others.
Neeraj Kumar Sahu.
Suchit then Mamata Kumari.
What are the allegations, by the way?
My lord, what happened, my lord? The informants party have a hotel, my lord. They was the veranda of the hotel. Some water came and gathered near a humps. When a truck or bus was gone, that was sprinkled into the body of this petitioner, for which, my lord, there was quarrel between the parties and counter case have been registered.
They belong to
One family. Bhai Bhoni, so Bhaujo Alga agent.
Simple, na?
Yes, they have granted bail even.
My lord.
My clients have granted.
Medical exemption report mu deich.
All right. At the instance of, let us go one by one.
My lord.
Get
Seta better.
1 by 500. First
Yes,
500.
5,000.
5,000. Okay. At the instance of opposite party number 2, opposite party allegation in the FIR. Allegation against the petitioner are phase 3 para 2. Charge sheet was filed?
Yes.
When the charge sheet was filed on, can you give the date?
The charge
sheet in the case. Can you give the date? No, you can't.
In my case, this is FIR number.
Affidavit भी तो क्या हो ना किसी नहीं charge sheet file है कौन है there is nothing FIR पे file कर दे quash कर दिया
मतलब charge sheet filed on 31st January 2022.
Charge sheet was filed on when the before the trial commenced, the parties have now settled the dispute, and on the ground of the settlement of the settlement in the court, they are being represented by their respective counsel and identified by their. They have filed their self-attested copies of their Aadhaar card to establish their identity, which are taken on the copy. Simply stating that they belong to the same family, and due to misunderstanding, the FIR was crossed. Now, on the intervention of the affidavit is taken. Mr. Ragada and Mr. Maharaj appeal for the state submits that since the parties belong to the same family and due to the misunderstanding, the FIR came to be registered against them. Now, since the parties have now settled their dispute and appearing before this court and has filed an affidavit before this court, there is no legal impediment in quashing the FIR. Moreover, FIR number so was. Okay. Next matter. Let me count how many people are there. Yes.
Next house is
1935. 1935. I recognize FIR.
This is a complaint. This is a complaint. On the basis of the complaint case, one CC case number 7 of 2022 was registered against the petitioners. Registered against the petitioner. in the appears to be a counter case registered against the petitioner.
No, that is, my lord, your lordship will kindly file charge sheet against two persons.
Earlier FIR.
Protest.
You are talking about earlier. FIR was this FIR. Aska PS case.
Second case ta moro. Second case ka FIR.
ये Aska PS case কথা বলছেন Aska PS case
792 of 2021.
792. After investigation, charge sheet was filed against FIR in the present petitioner exoneration protest petition in the form of one CC case number the court shows. After the 200 now cognizance has been taken against the court.
Cognizance was taken 4/5/2022.
Cognizance is taken, the parties have settled and filed a quashing petition being first case. First case na 792 to file.
Yes.
First case being CRLMC number 5000 up to so and so. This court by the order dated so and so has got the
By tomorrow also.
Order, my lord. But in the order portion, my lord, NBW was issued.
Paragraph 2 and 11 2023. Every time committee change. You are there in this matter.
RLMC number 118 of 2024 and another is 4424 of 2067 subsection 2 of the CRPC. For the police and the Ahmad Khan, my lord. Your lordship observe learned court below seeking regular bail and 2.
There also he had moved application 167-2.
No, my lord, they are challenging. Otherwise, go consider karnathile. That is in Perin Guru. Your lordship consider what in this matter applicable is, my lord, this order. Your lordship. Last paragraph, your lordship. For the foregoing pending till disposal of the case, we granted liberty to chemical examination report.
Where does it say? Where does it say?
The learned counsel arguing that matter.
No, where in this judgment, where does it say that chemical analysis?
Lord, in the Muhammad, sorry.
Otherwise, also you will be entitled to that then.
430, your lordship.
You are a citizen, every citizen.
I am state. Your lordship is considering we all are the citizens.
Don't say outsider. You are also entitled for bail. See, March 2023. So you are otherwise also you are entitled 70 kilos.
We nursing court ratios.
And I have taken a different view. And we have taken consider of Mohammed Arwaz also. That is my thought.
Your lordship, para 8 is purely applicable for my cases, your lordship.
Both the matter, give it to me. I'll give it.
Grateful.
I'll follow my judgment. I can't.
Your lordship may can consider your judgment that is applicable in my case, but my lord, para 8 of this order is applicable for my case.
I have gone one step ahead than para 8.
Your lordship.
That's the problem. Yes.
69.
Yes.
My friend perhaps not understand properly the mind of the Honorable Court. Your lordship may observe all the things and said that he is at liberty to approve.
That's what I'm going to do.
That will be better.
That's what I'm going to do so that see 70 kilo recovery. More than 1 year of already. Why are you going to all this thing? You will get the bail. I'll observe everything and
yes. 69.
May I please this your court, lordship?
Yes.
Your lordship, an order was passed by this honorable court to deposit the monthly installment by 30th March, but due to bar election, the counsel of the petitioner could not deposit the money. But he won.
No,
He approached.
this was NBW was cancelled.
Yes, your lordship.
And then what do you want?
So extension of time.
Oh, extension of time, you know. Okay. How much?
So 15th May.
15th May. Okay. I am giving you till 20th. Okay.
Write down.
I oblige you, Lord.
He is asking for extension of time.
नहीं ये application अलग है ये लॉर्डशिप में kindly turn to page 15.
15 up.
Page 15. Here the next item 69 though. Page 15 lordship. Yeah, next.
Which is the application?
Item CRM sheet 525 of 2024.
525.
Page 15. Hence the application for second para. Because you got it.
No, it's not there, but you read it out.
Hence the application for cancellation bail of Arao issue NBW against the accused person named Loknath Barik. The petition is Loknath Barik. And Rakka alias Rakesh alias Norsingho Charan Jena put up on 7/10/2023 for production of the accused persons. Extension
IA for modification. Dispose.
I'm passing it over. Sit and read it. Once again and tell me. 70 here. You read it out. You just help me. Yes.
70.
Yes. 70.
70 extension point.
For the extension purpose.
Surrender extension.
केबे तिला हम डेट दी थी 30 मार्च दी थी आपको कर दियो 30 मिस्टर महाराज 30 मैं कर दो 30 में you Mr. Mahapatra just see what is the name of her client.
My lord, I am just checking.
Name of the client.
Name of the client is Loknath Barik alias
Loknath Barik. I thought it's good.
Number 15.
70 कर दो हाँ
71.
71, let's see. I have filed four sets of paper books.
Sorry?
I have filed 4 sets of paper book already verified.
Okay.
Maybe accepted and fixed for hearing date.
It is fixed for hearing only. Are you?
Paper book by registry may be directed to supply a paper book to me.
You don't have register. You might have taken the copy.
No. Only filed. It has been listed for exceptions by your lordship.
Okay. Right.
Because High Court.
The petition submits that she has filed the 4 sets of paper book, appeal paper book. The same may be accepted and copy of the paper book may be supplied to the council.
My name may kindly be reflected in the cause list. Sanjay Kumar Das, Standing Counsel Vigilance.
Mr. Sanjay Kumar Das, whose name should also be reflected in the cause list. Please, the matter for
Fix for it. Date.
You tell, are you ready?
After vacation, it will come. After acceptance, paper book, it will come before your lordship. So, it will, in usual course, it will come.
Usual
Serious.
No, which year appeal is this?
Year 15, 2015.
15 तो जल्दी को जाना भाई.
past.
Date, we will fix the date.
Yes.
24th June.
Just up to the
24th June.
After vacation, your lordship may fix any day.
24th June.
Yes. After, because unless and until the paper book is supplied.
24th June they'll supply.
May.
Lot of time. 24th June.
नहीं मे मास रे पोस्टिंग करंतु तो सब आफ्टर वेकेशन कर देबे गुटी हेले
सीरियल आसीबो कोन
अछि एटा फास्ट
सीरियल
अछि सीरियल नंबर फास्ट अछि
We just want to regularize the thing.
Yes, ma'am.
Once the paperwork and everything is ready, then we will hear it and
already paper book ready only for
ready कोन supply है नहीं paper
verification है जैसे आप कोन supply
anyway June reception ठीक है
June reopening
हाँ 24
72, my lord, office is to verify. In the cause list, it has been indicated.
Yes,
the appellant has filed 4 sets of paper books which are not verified by the office. So, office is to verify whether it is in order or not. Thereafter, it will be accepted and copy will be supplied to department.
Office the registry is to verify the paper book whether it is in order or not. After verification, the copy of the same will be after verification, the same will be accepted and copy of the same may be supplied to the
Standing Counsel Vigilance.
Mr. Das. Your name is
reflected. No, name is not there. Sanjay Kumar Das, Standing Counsel Vigilance.
Name should be reflected. Okay. Least return to 24th.
Lordship, after vacation, Lordship. Yes, grateful.
73.
74.
73 na?
73 already mentioned.
Already mentioned adjourned.
So no paperwork has been supplied, office may be directed.
73 lekho on behalf of there what had happened is there is no instruction on behalf of the petitioner. So he said that I am not going to appear. So we have to appoint a right.
Otherwise, your lordship may issue notice to the appellant.
Issue notice to
Appellant.
Legal counsel Mr. Pushpalaka.
Somebody
एक तरह APA तो लिखा है ना issue notice already कराई खाली
Sanjay Kumar Das, standing counsel, vigilance.
Yes.
74
say younger sister case study.
yes.
ସେ କହିପାରୁନାହାନ୍ତି ସେଟା କଣ ହେଇଥିଲା ଇଏ ଲକ୍ଷ୍ମୀ କାଇଣ୍ଡଲି ଟର୍ନ ଟୁ page 12 page 12
12 of what
impugned order learned jemmer
running
page 12
yes lordship got it
MP order of page 12
running
page order dated 8/9/2023 at the top ekdam top page 11
8/9/2023
page 11
नहीं page 11
CRLMC 525
that's right 525 వచ్చి running page కూడా
running page 11 my lord running page 11
yes
my lord
11
order dated
11 ରେ ତ ଇଏ ଅଛି FIR ଅଛି
order running page 11 in the IA my lord
IA
yes my lord IA 883 of 2024
883 IA 883 okay
lordship got it
there
11
order dated 8/9/2023
then turn to page 12
yes
page 12 second para similar orders were passed the sentence starts similar lordship got it
regarding
yes no the jana honorable high court BLP number where the honorable high court had directed the accused to pay a sum of rupees 50,000 upfront and a subsequent to pay a sum of rupees 15,87,000 in 15 equal installments coming from 1/6/2023. Accordingly, this court had released him on bail on 27/4/2023 with a further condition that he shall not indulge in any criminal activities while on bail. The accused deposited an amount of rupees 50,000 at the time of bail, and on 1/6/2023 he deposited this first installment of rupees 1,05,000. Lordship got it? Then lesser than the stipulated amount, 1,800 कम थिला. However, thereafter he has defaulted in making any further payment. Moreover, the learned counsel for the complaint draws the attention of this court and FIR so and so 420 Kotak Sadar, wherein the accused Nrsinga Charan Jena had been arraigned and
because of the default in payment of installment NBW was issued.
then Lokanath asila. Table eta gala gote accused epata asila porkentra the learned advocate appearing both the accused person vehemently contend that honorable court had mandated payment to equal installment. It is nowhere mentioned in the order of the honorable high court that the installment shall be monthly. Further, they cite the pendants of a CRMC number 3 so and so preferred by accused Loknath Barik, IA number 1184 of 2023, arising out of BLPL number 113 of 2023, preferred by the accused Nrsinga Charan Jena before the honorable high court to plead that before this disposal by the honorable court, this court out to stay its hand on the matter. Finally, they submit that the bail was granted by the honorable high court. This court lacked the jurisdiction to revoke the same. The knowledge counsel for the accused Nrsinga Jena has also submitted that mere filing.
Why are you reading all these things?
Then say installment and all the fine cancel kar diji na bail ta cancel hi. The last finding da hochi hence the application for bail, the next page page 15, hence the application for bail cancellation of bail is allowed. Informant files cancellation bail.
And this NBW was now set aside by me and asked him to appear. With installment, he says that he doesn't have money to pay. That's what he wants.
Actually, your lordship, on 2nd April, we approached the Learning JMFC court to deposit the money, but we couldn't. But he didn't accept the same, so we want time.
All the money or one installment?
Sure.
Entire money or one installment?
Monthly installment money. 57,000.
There is no monthly installment as such. You have to pay the 1,57,000 rupees.
Okay,
15 lakhs,
15 lakhs.
15 lakh rupees.
15 lakh.
With how many installment it says?
It says, my lord,
15 equal installment.
15 equal installments.
Okay, your lordship, we will deposit it.
Oh, you seek instruction come. I'm
No,
keeping
sir,
it
the
tomorrow.
petitioner.
No,
No,
no, don't make statement, then your client may not be in a position to pay, then
ask your senior.
you will be in trouble.
Okay.
I'm keeping it tomorrow. You just ask.
Advance of the Kali bin.
How much you can deposit so that I can record it? 2 installment or 3 installment and cancel.
Ask your senior.
Okay. Ask.
Simple adjustment.
Tomorrow, huh? Yes.
74. Oblige you, lordship.
Lord, 74. The parties have arrived at a compromise, my lord. Today, my lord, they were to come for some difficulty, could not come, my lord. The marriage function.
When can they come?
My lord,
Second week of May, your lordship.
second week of May, 6th or any date. Except 9th, my lord, any date, my lord. 8th.
Yes, obliged.
Yes.
Please.
Next.
75.
75 May, please, my lords.
Yes.
My lord, on the last occasion, this court has directed the learned state council to obtain the case diary, and my lord, status report was called for,
Yes.
which is at flag, my lord.
Yes, Mr. Gola, do you have?
Flag A.
Status report is there, my lord.
Flag A.
my lord.
Flag A.
And I have also
Flag B, my
completed
lord.
case diary, my
Flag
lord.
B. That is status
Lord
report.
can see the
What is the case?
My lord, in this case, I have challenged the cognizance order of the learned court below. My lord, the present case has been instituted by the state level scrutiny committee for issuance of fake caste certificate. I was the there then Tahsildar of my lord, incumbent post for issuance, my lord. So, my lord, the dispute is without a valid sanction. The court has taken cognizance. So, my lord, for which I had challenged the cognizance order, and which is at Annexure 3, my lord. And the reason which was given, my lord, for taking cognizance, despite of having regard to the section 197 of CRPC, my lord, that due discharge of duty, if my lord comes to running page number 65. Has taken the cognizance.
What is the report?
My lord, status report was called for. Flag B.
flag B, man.
Flag B.
Flag B is the status report.
Flag B, so status of the trial, na?
Status of the trial, my lord.
But so far this petition is concerned, my lord, statute submitted showing him as absconder,
My lord, to that
thereafter cognizance
effect,
taken, my lord. He claiming that, my lord, the court while taking cognizance had not taken consideration 197(1), my lord. That can be taken at any point of time, my lord. Even if framing charge, my lord. He has been
No, my lord.
shown as absconder, my lord.
My lord, to that effect,
certificate, my lord. The sole main accused, my lord, is a lady, my lord. He was originally belongs to general OBC caste, my lord. Adopted by one of the SC community man, my lord. And obtained, my lord, the SC certificate, and thereafter he engaged in his service, my lord. And when it came to
certificate is issued by this
this man,
I have issued, my lord.
for that is, my lord, on I with
but
this.
if there is a that girl is adopted SC,
By SC.
then
By birth, my lord, is general.
adoption is valid adoption. What will be the
No, there is no such valid adoption, my lord.
My lord,
No valid adoption, my lord. Only, my lord, adopted.
there is a possibility of outcome for settlement? Someone.
Total
24 lakhs.
24 lakhs.
You have given 7.
7.
He is your brother. Persuade him, give some installment and do something. And
My lord, I will take
That,
instruction.
that money is still in the account of my friend's client because that was freezed by the police during
then
court.
give it.
I will take instructions.
Exactly.
Today in the court, my lord.
Right. There is a possibility of outcome for settlement.
Therefore, to explore the possibility of settlement, the matter is adjourned. They do this interim order.
Interim order. Great.
77.
My lord's permission, may I say one thing?
Yes,
Sir. I have a matter before your lordship. Today's court list, that is 105. 103. That is a criminal appeal vigilance department. My friend was also waiting for me.
Mr. Das, na?
Today I am completely exhausted. So,
Mr. Das. Yes.
105.
103.
103. Sorry.
103. Yes, paperwork may be supplied. No paperwork is used me. Office may be directed to supply.
Are you ready?
Yes, yes.
You are ready. Then we'll put it in next week. Paperwork I will ask you.
After vacation, summer vacation.
After vacation.
If every matter will go after vacation, this side of the vacation also some credit.
Let myself ready manner to argue before.
You are just sitting standing out on behalf of vigilance.
No, you are always ready.
He runs to this side.
No, it's all right. You are always ready. Keep it this side. This matter will finish it up. At least 1 2 appeals should be disposed of. Otherwise, see, there is no point, 1 2. 2 courts have convicted you. Two courts. Sorry, appeal.
Only vigilance.
It's a convicted. Yes, they have to argue.
Your lordship may fix to May 2nd week.
Second week, yes. 6th, 7th, 6th, 7th, whatever.
16th of 7th.
13th, 6th or
13th.
All the appeals.
Monday, we have that.
Monday, 13. 1-3. Race is directed to supply the paperwork to Mr. Sanjay Kumar Das.
My name may be reflected instead of the names appearing in the cost statement.
Yes.
Those names may be deleted. No. Distinction appealing Mr. Sangram Das. So,
appeal copy दे दियो ना
सब अपलोड दे दे
copy सब upload दे दियो why should he will wait keep on court time waste होती यदि appeal होती ना तो copy दे दियो record and take endorsement appeal copy अपना you send your junior to the registry. I will ask them all the paperwork of appeal paperwork of 2015. Only let us consider it in 2015. These are oldest matter. About 49 matters are there. At least some matter we can, Yes.
77.
May I please, your lordship? 77, I am appearing for OP number 2, my lord.
Yes.
All of the appeals for my lords today listed and also will be argued by me. So,
then copy same order. Criminal appeal होती है.
All appeals will be argued
Mr.
by
Das Rishi is directed to supply the copy. Criminal.
Item 99 to 105.
99 to 105.
तो पूरे same order कर दो. और name has to be reflected and Rishi directed to supply the copy of paperwork and accordingly the देखिए list धीरे कर list कर दो.
Maybe listed after summary officer.
Let us see.
Except the matter which your lordship fixed to 30.
We'll see.
All the other matters may be after vacation.
101. 101.
ମତେ ଏକଲା କରିବାକୁ ପଡିବ ନା
Vacation ଆଉ ଗୋଟେ ମାସେ ଅଛି ଆଉ ଆପଣ ମାସକୁ କାଇଁ 1 month ଅଛି vacation.
one matter would be argued in 1 day because vigilance matters your lordship will be
half an hour.
No happen. It will take judgment, deposition, witnesses.
Don't worry, you read and come, I'll also read and come.
Item 100, your lordship, criminal appeal, but it was had. Written note of argument, judgments, all the things I have filed, it is in the paper book.
You have given copy.
My lord, the copy of ସବୁ ଅଛି ଆର argument ସେ ଆର ଜଣେ advocate argument କରୁଥିଲେ.
ତାହେଲେ ଆପଣ କପି ଗୁଡା ଦିଅନ୍ତୁ
Himant Das was appearing.
He
was arguing, your lordship.
ଏଇ କେସଟା decide application ରଖିଦିଅ ବାକି ସବୁ ଗୁଡାକ after vacation.
Item 100.
Because he is ready, written submission, everything is ready.
But item note
can finish it up.
100. Item 100.
101 also ready.
But you have an individual matter, but he has to prepare. Na so many cases he can't prepare.
I will have to argue all these matters.
So therefore, he should also be ready. Na? Otherwise, what is the fun in?
Already Srimant sir appear କରୁଥିଲେ argument ବି ହେଇ ଯାଇଛି ସବୁ ରହି ଯାଇଛି ସେଠି
Next. Yes.
77, I am appearing for OP number 2 in this case. I pray some time, I have sought for instruction.
Don't to appear for opposite party number 2, 6 time. Adjourned. Who is appearing? You are appearing.
My lord, I am for the petition, my lord.
You have any objection? No.
My lord, interim order to continue, my lord.
Interim order to continue.
My lord, it will come after vacation or before vacation?
On 6th.
He will give the date according.
Week commencing 6th.
He'll give the date according.
My lord. Only, my lord, it may not be on 9th May, my lord, I pray. Except 9th May, any date, my lord. Grateful, my lord. Interim order to continue, my lord.
79.
May I please? But in this case, petitioner is a brother-in-law, opposite party number is a wife. I DB case against the opposite party.
Opposite party number?
Opposite party number 1 is a wife, my lord.
Wife of?
Wife of opposite party number 2.
Okay.
He filed an application annexure 1, section 12, claiming some maintenance. Father died long since. That is a separate mess. Her brother-in-law had no relations with their family. In the meantime, opposite partner wife also filed a divorce proceeding against her husband. So in this,
the now section 12 is filed against the
brother-in-law and husband. And also extended order in earlier order. So I have no locus standi to connect with this case. Is it possible to petition to appear?
Who is appearing?
Who is appearing, but not last date we asked nothing. Not after vacation also.
Despite notice.
I am appearing, Lord. I am appearing in this case. I am appearing in this case.
Yes, yes. What do you say?
Lord, I will draw your lordship's kind attention of their petition, page 4. Page 4.
Page 4.
Paragraph 2. Paragraph 2. The petitioner is the elder brother of pro forma opposite party number 2.
Where are you reading?
They are petition. The 482 petition, page 4.
Para
2.
Yes.
The petitioner is the elder brother of pro forma opposite party number 2. The present petitioner and my husband are 2 brothers.
Then why should he will maintain you?
Yes, my lord. Your lordship may.
You have a fight with your own husband.
I am coming.
And you ask the brother of the husband to maintain you. What is
I am coming to that point. Yes. Your lordship may kindly see the cost title.
Cost title?
Cost title. The Devashish Behra, the present petitioner. Son of so-and-so, late so-and-so at Raghunath Mandir, Surya Behar, behind Nishavan Tagis, Arundaya Market, Badambadi, Cuttack. Then the address of the opposite party number 2, his brother, my husband. Raghunath Mandir.
What is this? No.
They are claiming that we have no domestic relation with that the opposite party number 1. That is why the domestic DB proceeding is not maintainable.
After all, I can understand he has his own life. The brother has his own life, his own family. You fight with your husband and you ask brother of the husband to pay the money. What is
But his wife has filed a domestic DB proceeding. His the wife of the present petitioner before the learner JMFC Cuttack. Against me, against my husband, against my father.
DB case.
Yes, DB case. Admitting that, stating that we are in common mess and there is domestic violence.
Where is that?
Yes, I have received the someone from that court and I have appeared, entered my appearance.
Where is that? Have you filed all these things?
No, I have just appeared, filed my Vakalanama.
Mr. Ashok Kumar Behra enters appearance for opposite party number 1 and 2. One 6 filed to 1 only.
1.
You don't have a relationship with the husband, okay, once. And seeks time to file the response. Response. Adjourn it. To interim or to country. Yes.
His wife is claiming that we have the domestic
You
relations.
file the
I have-
reply.
Yes,
You file the reply. Yes. Yes.
Revision matters. Only revision matters.
Revision कितना हो?
84.
Yes.
Lordship, item 84 and 80, I'm praying for after vacation, Lordship.
Why?
Lordship, need some time to prepare, and the Lordship also, this is not perfectly visible to read, Lordship, for which I'm praying.
Last week of second week of May लगाओ. Second week of, we'll see. Yes. Next.
Grateful man.
85.
86.
86.
Yes.
Against the conviction only. The convicted under section
25. Conviction 1 year.
1 year and fine 3,000.
3,000. Show me. And 323, 4 months. 341, 1 month.
1 month.
Show me the injury.
But injury report that
page 4, my lord. Pedal 5, Bhagirathi Meher is the injured victim.
Page
He stated his evidence.
Page 4.
My lord.
Para?
Judgment.
Judgment.
My lord, para, second paragraph.
Brief act.
Trial court judgment, my lord.
Trial court judgment.
My lord. Pedal 5 is Bhagirathi Meher, the injured victim. He stated in his evidence that the occurrence took place between 7:30 p.m. to 8 p.m. on
Where are you? PW2.
At a Pedal 5, my lord.
Santa Mera.
My lord, Pedal 5, my lord. Bhagirathi Meher. My lord, trial court judgment, my lord.
Which paragraph?
40,
Which page?
43, 44 page, my lord.
44.
My lord.
Okay. PW?
5, my lord.
Okay. Bhagirathi.
Bhagirathi Meher, the injured victim, he stated in his evidence that the occurrence took place in between 7:30 p.m. to 8 p.m. on 5/8/1997 near Manabandha Adi. When he was going to his house by a cycle, the accused person assaulted him by stick to his back. As a result, he fell down on the ground and his cycle was damaged. The accused, Tanu Meher, gave a stick blow on his left leg below the knee and to his right leg, causing bleeding injuries. When the accused person tried to kill him by a stick to his head, he raised his both hands to save himself. So his both hands broken, and he also sustained bleeding injury on his left eyebrow. Thereafter, he lost his sense. The cross-examination was stated that he had been examined by the police after coming from the hospital, my lord. And Doctor, my lord, then paragraph, my lord, Pedal 7, Doctor, my lord. He stated in the evidence that on 5/8/97 at about 8 p.m. on police requisition, he had examined Bhagirathi Meher Pedal 5 and found the following injuries, my lord.
Okay, left eyebrow.
My lord. And broken injury also there, my lord. Rightly, my lord, the conviction under section, my lord, the 325, my lord. Doctor, my lord, then
that doctor that was examined was the he is not the radiologist, my lord.
No.
And there is that.
But the injuries number 1 to 4 are simple in nature, might be caused by hard and blunt object. The doctor also stated in the evidence that after his examination, the patient was shifted to VSS Medical College and Hospital, Burla, for X-ray were taken, and there the latter on produced before him by police on 7/9/97 X-ray of a right knee and a legs showed fracture of a tibia in the upper half, which relates to the injury number 4.
Injured witness corroborates with
medical evidences.
No, my lord. That X-ray plate was supplied by the injured, my lord. That not by police submitted that plate, my lord, for collect from the injured, my lord. That is there, my lord.
The injury, in nature, the nature of injury is grievous, which might have been caused by hard
And the engine number 3, which not, there was no X-ray plate, my lord. Only that mentioned that is the grievous, my lord.
Report with respect to injury number 6 and 4. Mark, just see injury number
4.
See, come to 44. Which injuries are grievous? Injury number?
Injury number. In the
3,
top
4.
next page, in cross-examined by the Learned Defense Counsel, Schedule 7, Doctor, the injury can be possible by single object or by multiple object. He deposed that cross-examination that the injury number 3, 4, and 6 are grievous in nature. 3, 4, and 6. 3, 4, and 6.
4, 6 grievous.
3, 4, and 6. Read all 1,
3, 4, and 6.
Read all 1 penetrating injury on the left leg.
Opinion 3, 4,
6,
and 6. Grievous. Now come to the last paragraph. X-ray of a right palm fracture upper lip stone, which relate to injury number 6 and which is grievous in nature, might have been caused so and so. He is relying upon this paragraph. Doctor has also stated in his evidence that after his examination, the patient was shifted to so and so medical college and Purva, and X-ray were taken there, and which was later on produced before him by police. That's what he says. The X-ray was produced by the police.
By police. Police stated that he was.
X-ray of a right knee and the leg shows the fracture of TVS also relates to injury number 4.
Police produced the X-ray.
How does it make difference?
Police
The police produced by produced that
because he was taken to different hospital. So therefore, police collected
often the same.
police obtained from enjoy, my lord. That not from medical, my lord. On in your statement is clearly.
He proved his report in respect of Exhibit 6. Exhibit 6 proved. Exhibit 4 proved. Injury number 4 proved.
And a conclusion paragraph 8, my lord.
Proved the requisition of X-ray.
And findings, paragraph 8
requisition is also proved.
Paragraph 8 is the findings, my lord. On scrutiny of the evidence of the prosecution witnesses, I find that all the prosecution witnesses, except Schedule 6 stated about the alleged occurrence, the informant well corroborated the affair. Similarly, Schedule 5, the victim injured, narrated.
My lord, informant in the affair, informant stated that he was not the eyewitness, my lord. Subsequently, in statement, he was stated that he is the eyewitness.
This kind of cases, the injured witness is much more important. Injured witness and medical corroborates. Thereafter, this is the problem. How will you get out of 325? Think over that.
Only he has to tell how many days he is in custody.
How many days you are in custody? Tell me how many days. Which is there, na? Soft copy will see. ଆପଣ କୁହନ୍ତୁ 323 କରିଦେବା
barcode is there, barcode ଦେଖି
323 କରିକି already undergone
fine
ଆପଣ ଫାଷ୍ଟ କୁହନ୍ତୁ କେତେ ଦିନ undergone ସଫ୍ଟ କପି ଦିଅନ୍ତୁ ଆଜ୍ଞା ଦେଖି ଦିଅନ୍ତୁ ସଫ୍ଟ କପି ଆରେ ନୋଟ କରିଦେବେ ଦେଖି ଦିଅନ୍ତୁ चलो रिजर्व
87
ये सब कभी देखी देवे रड़ा उठी आपण भी देखी यस
made page versus prepare a short note of written note of submission versus
written submission yes
Your Lordship's story of the affair is this petitioner, this accused petitioner, Lordships, has entered into a school premises with a motorcycle chain. At that moment, one teacher was there in the school and students are there. Seeing the in the drunken condition. That is the allegation. Seeing him, the students are in fear outside the classroom, and the teacher snatched away the motorcycle chain
From?
from the accused. There was no assault, no injury also. And the Lordship's petition has been convicted on section for 3 years and pay fine for 3,000 in default of to undergo RI for 2 months, and for offense 452 of IPC. And further sentenced to undergo RI for 6 months and pay a fine of 500 for offense 323, your Lordships. And in default to RI for 1 month. The substantive sentence are drawn consecutively, and period already undergone as UTP, that is from 28/8/2005 till 29/1/2006 be set off as per the provision of 428 of the Procedural Lordships. Your Lordships, prosecution has examined as well as 10.
You come to your submission.
Yes, Lordships.
Page 5.
Here, your Lordships, I am perusing your Lordships. It's important to mention that the material on record, it is found except the informant PW1, there is no other eyewitness of the occurrence, Lordships. Evidence PW1 is the informant, Lordships. There is not any assault by the accused on him, nor has he sustained any injury, Lordships.
Okay.
From the evidence of PW6 and PW10, they are the
Seizure witness.
seizure witness, Lordships. They have not supported the prosecution case, Lordships.
Motorcycle chain.
Yes, Lordships. Okay. They have to based upon the PW7 and 8. They are the child witness, Lordships. That is contrary to the.
They are the students.
They are the students. They are not there in the. They are not there inside the classroom. That is the statement of evidence of the PW1 and FR story also. So that evidence cannot be relied upon. That is a tutorial evidence, Lordships.
What are the age of this?
They are students, Lordships.
Minor.
The students are minor, Lordships.
Minor.
Except these, Lordships, there is if the 323 is not made out, Lordships. If 323 is not there, so 452 also may not attend in this case, Lordships.
In this case, 3 witness evidence is right. Pedal 1 is the informant and the victim. Pedal 8 and 7 and 8, my lord.
1, 7 and 8 are the.
My lord, page 9, my lord.
9.
Pedal 1 had deposed that on a
Page 9. 1 minute. Page 9 of.
Second paragraph.
Trial court judgment.
Trial court judgment, my lord.
Yes.
Paragraph 6, my lord.
1 minute.
Paragraph 6.
Paragraph 6.
My lord.
Paragraph 6, yes.
Pedal 1 has deposed that on 11/8.
1 minute. 1 minute.
Madam.
Para
6.
6 trial court. Para 6 of trial court. Yeah, reading.
Pedal 1 has deposed that on 11/8/2005 at about 11:45 a.m. he was teaching in class IV on
Of
Madhavasi primary school. The accused rushed into the class room being armed with a motorcycle chain. He was in the drunken condition and frightened the students, which he prevented. When he snatched away the chain from the accused, he abused him in filthy languages and threatened him. Thereafter, he went away. He lodged a written report at the Station Bazar police station. Marked as Exhibit 1, FR Exhibit 2. Then next page, my lord, page 10. Pedal 7 and 8, my lord. Next page, my lord.
Page
10.
10.
My lord. First paragraph. Pedal 7.
1 minute. 1 minute.
That is important, my lord. Say 6 continue. 6 paragraph continue.
Yes.
Pedal 7 and 8 child witnesses, my lord. Being student of the school, as such, their evidence is to be carefully examined. Pedal 7 has deposed that at about 5 months back, the accused came to their school with a cycle chain, while Pedal 1 was teaching mathematics in their class, that is class IV. The accused threatened all of them, dealt slap to them, and abused Pidol 1. Pidol 1 snatched the chain from the accused. The accused had dealt a slap on the cheek. During cross-examination, he admitted the police had examined him 1 and 2 days after the incident, and he did not stated before the police that the accused was under the influence of a liquor. When the accused attempted to inflict a blow with the chain, the informant caught hold of the same but did not sustain any injury. There was mark of assault on his cheek, but he was not medically examined. He denied the suggestion that being tutored by the informant, he was deposing falsehood. The aforesaid evidence of Pidol 7 corroborated the evidence of Pidol 1 on the material particulars. Pidol 7 is also a victim of the assault threat of the accused. Similarly, Pidol 8 is also a student of a class IV of that school.
You tell me, the allegation and according to the trial court and appellate court also, they say that he was drunk. He came with a motorcycle chain, entered into the classroom, gave a slap to the teacher. And
for that in the 452,
the teacher says that there is no medical examination of the teacher also. There is no injury admitted. What are the evidence you have laid
52 entered in the
to prove that he was drunkard? He was
one teacher and 2 of the students. Why should we disbelieve the childhood's evidence?
Your Lordship,
Childhood test, they can't.
Your Lordships, may I peruse?
They are student of the school.
Permitted to peruse the first FIR, Your Lordships. First the FIR also I am perusing.
What is your case is 323 is not made out.
Yes, Lordships. And Your Lordships, the child witness, their evidence may not be taken into consideration as because no victim statement, the informant nowhere stated that they have assaulted the students, Lordships. They are not there. That is my point, Lordships. Lordship, kindly I am perusing, Lordships, relevant portion. ମୁଁ ପଢଉଥିବା ରୁମ୍ ଭିତରକୁ ଜବରଦସ୍ତି ପଶି ପିଲାମାନଙ୍କ ମଧ୍ୟରୁ କାହାକୁ ଖୋଜିଲା ଓ ଅନ୍ୟ ପିଲାମାନଙ୍କୁ ବାଡେଇବାକୁ ଧମକ ଦେବାରୁ ପିଲାମାନେ ତାକୁ ଭୟ କରିବାରୁ
Who are you by the way?
ଆଜ୍ଞା,
You are outsider.
I am outsider.
Well established.
ମୁଁ ତାକୁ ରୁମରୁ ବାହାରି ଯିବାକୁ କହିଲି। ସେ ରୁମରୁ ନ ବାହାରି ସୋଦା ସହିତ କରିବାରୁ ପାଠ ପଢାରେ ବ୍ୟାଘାତ ଥିବାରୁ ମୁଁ ତାଙ୍କୁ ବାଧ୍ୟ କରିବାରେ ସେ ମୋତେ ସ୍ଲାଙ୍ଗ ଲାଙ୍ଗୁଏଜ ଲର୍ଡସିପ୍ସ ଶ୍ରେଣୀରୁ ଯିବି ନାହିଁ, ମୋର କ'ଣ କରିବୁ, ସେହି ଦେଖାଇ ଦେଲେ ଜୀବନରେ ମାରି ଖତମ କରିଦେବି ବୋଲି ଧମକ ଦେଇ ସେ ଧରିଥିବା ଚେନରେ ମୋତେ ମାରିବା ସମୟରେ ମୁଁ ଚେନକୁ ଜୋର ଜବରଦସ୍ତି ଧରି ପକାଇଲି। ସେଠାରୁ ଚେନ ଛଡାଇ ମୋତେ ଅସ୍ତ୍ର ଭାଷାରେ ଗାଳି ଗୁଲଜ କଲା ଓ ଧମକେଇଲା। That is the allegation, Lordship. Evidence, Lordships, I am deposition of the PW1 I am perusing, Lordships. That is, Lordships, on 11/8/2005, I was a teacher in the Mandba Sahi Primary School. I know the accused person present in the dock today. At 11:45 am, I was taking class in class 4. At that time, the accused present in the dock rushed into the classroom, being armed with the motorcycle chain. He was in drunken condition and he frightened the students, which I prevented. When I snatched away the chain from him, he abused me in filthy language and threatened me. Then he went away. Thereafter, I lost the affair, Lordships. So nowhere he stated that he has assaulted the minor students, Lordships. That is the informant story, Lordships. Informant evidence also.
Come to 452. How much you have undergone?
Pardon, Lordships.
Undergone.
Yes, undergone, Lordships. 12/8/2005 to till 29/1/2006, Lordships. 12/8/2005 to 29/1/2006, Lordships.
5 to 29.
29 1 2006, your lordships.
So how much it is roughly?
It is, your lordships, no, those near about 6 months, 5 months, your lordships. And your lordship, seizure witness not supporting the prosecution case, your lordships.
Will convert to already undergone.
May extend to 7 years, lordship.
May extend to 7 years. The incident is of 2005.
It's a bad
In fact, your lordships, if there is 323 may not be made out in this case, your lordships. When your lordships informant is not saying that he assaulted the students, your lordships.
Even with
No, but that is there for putting any other person to fear or hurt.
Fear, that is not,
So I'm not 323 is not made out.
Yes,
I'm taking out. I'm taking it out.
Yes, lordship.
But I'm talking about 452.
452, lordships, kindly see, your lordships. What is the 452, says?
452 is made out.
Yes, no, your lordships. I am saying, your lordships. I am finishing the 452, lordships.
Whoever commits house trespass.
House trespass.
452, lordships.
Yes.
Whoever commits house trespass having made preparation for causing hurt to any person or for assaulting any person, lordships. Or for wrongfully restraining any person or for putting any person in fear or hurt.
Yes, or putting any person fear of hurt.
Right, that is
there. That you are coming under that. That is the problem. So therefore, 323 gale bhi ei jinsa
yes, lordships.
Undergone kar do.
Yes, lordships.
ठीक है? That's what is there. Undergone. Judgment is there. Yes. Next, 445. Let us see how good for you.
88.
88. Anybody is ready?
Item 97, my lord.
Huh?
Item 97. There is no instruction from my client, my lord. So yesterday I was mentioning
97.
97. Only
so you want to get yourself.
Your lordship will ask him to assist the court for that reason, my lord.
Because my memo may be taken on record. Otherwise, I cannot argue. My lord. There is absolutely no instruction from the client.
Okay.
Only thing is that I am raising the plea of Section 4 of the Provision of Offenders Act. That may be extended to him.
What?
You tell me whether it will be embarrassing for you to appear or
naturally, lords, it will be embarrassing for me to. I leave it to a lordship. Accordingly, I am filing a memo. Lordship may produce the memo.
Same council there, that person will
some problem.
It will be better.
Better unnecessary. Tomorrow he will say something.
Otherwise, you must notice to the petitioner. It will be better, madam. He can engage a council, otherwise you must engage any.
Right, and Mr. Pradhan, the council for the petitioner has moved a memo seeking to withdraw himself from this case, and he submits that he could not contact. And he has been trying to contact his client, but to no avail. But to no avail. Memo is taken on record. Mr. Pradhan is discharged from the case. Issue notice to the petitioner. Issue notice to the petitioner.
My lord, item 93, my lord.
93.
93, my lord, as per the direction of your lordship, my lord, I have obtained the information, my lord, the petitioner, single petitioner, and who is no more, my lord.
93.
I am sending the report.
93. The sole petitioner. Placed on record the instruction obtained from IIC.
His son has. His son has.
Appearing appears. it is reported that the sole petitioner in the present case has been expired.
Information has given by his son
Expired.
and the
The
Sarpanch.
same information is collected from the son of the petitioner and placed the same by way of the written instruction dated 16/4/2024. It is taken on record in view of the aforementioned the revision stand 70.
Item number 89. Item number 89. The Lordship on last occasion directed the IIC Daspala police station to ascertain the status of the petition and inform by this honorable court. But if he is dead by this date, my lord, the matter has become infructuous.
But it stands 70.
Yes.
Yes.
So
The report hasn't come.
item 89.
89 ରେ କିଛି report
So
ଆସିଲା?
I have sent a letter, my lord. So I have not got any response from.
89 ରେ ବି?
Yes, my lord. My lord, no, my lord. Petitioner is now 82-year-old and suffering from the genetics health problems and could not move from his house, my lord. He is ill, my lord. And suffering.
So will you wait till he dies or he dies?
No. Since my learned senior is in government panel, he cannot conduct this matter. So if your lordship considers, if your lordship accepts my.
A.R. Das, my lord.
Yes.
Is additional commenter.
You do it.
Yes. If your lordship permits,
he is appointed MLK Skuri tomorrow.
Yes.
Come tomorrow, we'll 82 years. We'll take it.
Item 90.
Item 98.
Let him die peacefully.
Item 90, madam.
Lordship, item 98.
Tomorrow you get paper book, photocopy. Tomorrow you come.
In item 98, Lordship has sought for a one-page note. That here.
98.
98.
Tomorrow it will remain. It will remain tomorrow.
Item
We'll
90.
take it up.
Lordship may fix it to any other date except tomorrow. I have some personal difficulties too.
Right. I'll have day after tomorrow.
Yes.
Day after. Because see, he is 82-year-old.
Yes, sir.
He do it at least honorably. Let us execute him so that.
Yes, sir.
Shanti the motive. कौन करता
गाड़ी आगे धोरा है जी 500 लीटर ସେଥିରେ chemical
only 2 years.
chemical examination है ही नहीं
2 years.
lordship knows the consequences, so
And do that. Therefore, I am saying tomorrow.
I have some personal.
Okay, day after tomorrow.
Yes.
Day after tomorrow, top loge do.
Yes.
Item 90, madam.
86. 86.
All other matter will remain.
2 days.
ନା ନା ପୁଲିସ ଆରେଷ୍ଟ କରିଥିଲା କୋର୍ଟରୁ ସେଭ୍ କରିଥିଲେ
Available offense ଥିଲା. Available offense.
ନା ସେଭ୍ ଆଇସି କୋର୍ଟରୁ ବେଲେ ପଳେଇନି पुलिस अरेस्ट कर आनी चाहिए
ओ ये कर दो फाइन कर दो फाइन कर ता लिख दो फाइन लिख दो 23 कन्वर्ट करी फाइन कर ठीक है
My lord 96
next 357 करके we will give it to victim.
My lord item 96 we both parties are present next week it may be taken up 96 item
you want adjournment
next week my lord
it will remain in the board sir you tell me let it be remain in board we will keep on adding which matter is arising how